Item number 15 is a whole pending case, my lord, no doubt. But I have taken the consent of the other side, but only for the day that is makes on next Tuesday, my lord. Because another 2 matter, it is a Supreme Court, my lord, it is referred back to the
Item number?
item number 15, my lord. Only for my lord, today, my lord, next Tuesday, I will do the case, my lord. I have taken the consent of the other side.
As prayed for by Mr. P. Mohanta, learned counsel for the petitioner with consent from the other side, relist this matter on such and such date.
On next Tuesday, my lord. That is on 29. Must-
May I please, your lordship?
Yes.
The consent of other side, lordship, I beg to mention, I have item number 7 to 12, lordship.
7 to 12.
Yes, your lordship.
You are for the respondent.
Respondent, lordship. In this case, what I have.
Who is appearing for the petitioner?
I have taken consent, lordship.
You've taken consent.
Yes, because the instructions are not coming, lordship. Yeah. I pray for some more time after 3 weeks.
As prayed for by Mr. S.S. Roy, learned CGC.
Lordship.
Learned counsel for the respondent with consent from the other side, relist after 2 weeks on a date to be fixed by the registry.
Lordship, let it be after 3 weeks, lordship.
All right, 3 weeks.
Right.
Any interim or anything
No,
there?
no.
May this lordship, I beg to mention item number 3 with due consent from the other side. My lord, I pray that this matter may be adjourned for a day.
You are supposed to file your return, reply. Have you filed?
My lord, not yet.
Then why are you adjourned? By seeking for an adjournment, you wait. If you have to file, if you are filing, we will pass an appropriate order.
My lord, my senior is in distress today.
Check with your senior how much time is required to file the reply affidavit.
My lord, I need a week time. A week time.
Then let the matter be called. You wait.
Please, your lordship.
Yes.
Lordship, I beg to mention item number 1, lordship. It is consent the other side, I pray for adjournment for today, lordship.
1.
1,
Affidavit in opposition,
we have already filed, lordship.
you have filed.
We have filed.
Who's appearing for?
I am appealing, my lord.
Well, item 1, what is the requirement for mentioning,
My lord, my
Mr.
lord.
Counsel? Will we just call? Can you not wait for some time?
That is why I am sitting there, my lord.
Yes, any more?
May I please, your lordship, I beg to mention item number 23, lordship. I'm praying for adjournment, my lord. This matter may be fixed on 24th or 29th, my lord.
23.
23, my lord.
You are for?
I'm for the petitioners, my lord.
You are Mr. Barbhuya.
Yes, my lord.
Have you taken consent from the
My
other
lord,
side, government?
State is there, my lord.
As prayed for by Mr. Y. Barbhuya, learned counsel for the petitioner with consent from the other side, relist after 4 weeks on a date to be
My
fixed
lord,
by the
may be
registry.
fixed on, my lord.
Next.
May I please, your lordship? I beg to mention for listing admission matter was fixed for today.
Yes,
Please, your lordship. Lordship, I beg to mention item number 21, lordship, for adjournment.
21.
Lordship. Lordship, we are unable to contact the petitioner. We have to get some instruction, lordship. I'm for the petitioner.
Have you taken consent from the
Lordship.
PNRD and finance?
No, lordship, I'm unable to get.
Inform them.
Lordship.
You see, if you want to make a mention, just because the other side is some government advocate doesn't mean that you will not take his consent. There are special standing counsels for departments. They are not here in the court.
Lordship.
They'll be waiting afterwards. How will they come to know that this matter has been adjourned in the morning? So you wait for your turn. We'll accommodate when the matter is called. Yes, please call the rest. Yes, item number 1. What was your prayer? Where is he gone? You want to file? Affidavit, affidavit is filed.
Pleadings are complete, my lord. Date may be fixed, my lord, because my lord.
This matter is for admission.
Admission, my lord.
What is the matter?
Matter is, my lord, non-payment of pension, my lord.
Pension.
Family pensioner benefit.
Why family pension has not been paid?
Because, my lord, the private respondent, they file an objection before the government, my lord, not to disburse the payment, my lord.
On what ground?
Because, my lord, I am the legally married second wife, my lord.
You are the second wife.
Legally married, my lord. But she was divorced, my lord, by a decree of divorce, my lord.
This matter can be fixed for
My lord.
hearing,
My lord.
admission stage or admit and fix it.
Admission stage, my lord.
It appears that pleadings have been completed. I'll admit and fix it immediately for hearing.
My lord.
The matter requires of. Are you going to file anything?
As per my instruction, lordship, it is not able to, he is not able to submit the next of kin certificate.
That's all right. You have taken that stand. The matter has to be adjudicated. Yes, Mr. Chutia?
So if they send the proposal to the pension fund, I would consider. But as on today, we have not received any instruction.
Who has to send the proposal?
Department, irrigation department.
Why are you not, Mr. Upadhyay, why the proposal has not been
Proposal has
sent?
Not been sent, Lordship, because there are two ways, first of all. Secondly, Lordship, the petitioner, Lordship, is not able to submit the required documents, Lordship.
Where is that stand in your
Lordship, I
affidavit?
have not filed my affidavit, Lordship.
Then why are you?
I will file, Lordship. The instruction is there.
কাটি দিয়া এইটো। See, these are matters of relating to pension. I don't see any reason of keeping this matters pending. If this is the position, I think this matter, if you all agree, can be also disposed of by directing the petitioner to file the relevant papers before the authorities, and the authorities will consider both the claims and do the needful.
There is one problem, my lord. I have applied for the next of kin certificate. Only because, my lord, she has, my lord, filed an objection. That is why NOK has not been issued in
But
favor.
how will the court consider all this now? This is, if she is the first married wife,
But she divorced, my lord.
Divorced.
Divorced.
Challenge the family.
No, my lord, but decree is not challenged, my lord.
if you don't want a disposal, that is
No.
another thing. Mr. N. Upadhyay, learned Standing Council Irrigation Department, has submitted that he has received the parawise instructions in the matter, which indicates that the departmental authorities are ready to finalize the pension papers of the deceased husband of the petitioner as soon as she submits the necessary documents, i.e., the legal heir certificate and the next of kin certificate. Stop. On the basis of such endorsement of the Learned Standing Council, this court Mr. T. Gogoi,
TK Bhuyam.
TK Bhuya, Learned Counsel for the petitioner, submits that since the next of kin certificate is not being issued,
My lord.
as there is an objection filed by, as the objection filed by the respondent number 5 is pending,
Fine.
he could not obtain the same. The petitioner could not obtain the same. Be that as it may, let the aforesaid instructions be placed by way of an affidavit. In the meantime, the remaining respondents may also file their affidavit in opposition if they so desire. Petitioner is also at liberty to file reply affidavits if he so desire, if she so desire. Relist after 3 weeks on a date to be fixed by the registry. Okay, return the parawise.
Item number 2.
Lordship, your lordship, by the order dated 1/4/25, some direction was given to obtain instruction. Lordship, I'm waiting, it's not yet
All right.
issued.
How much time do you need, Ms. Sharma?
Lordship, I need 2 to 3 weeks, 3 weeks, Lordship.
Lordship, I have a small prayer in this matter, Lordship. And Lordship, may kindly fix a date, Lordship, in this matter, Lordship.
Your prayer is for fixing a date.
Yes, Lordship. Till 2020, I am
I
hanging,
was
Lordship.
thinking you would have asked something more.
No, Lordship.
As prayed for by Ms. B. Sharma, learned CGC, the matter stands adjourned to such and such date to enable the respondent to
No, very good, very good. Yeah, very good.
obtain the instructions as directed earlier by this court by order dated 1/4/2025. Date to the
Item number 3.
Yes, invalidation from service,
My
yes.
lord.
Affidavit is filed, Ms. Sharma,
Lordship,
yes,
I pray a week time, my lord, for the adjournment,
to file reply.
my lord.
Your name,
Kiwa Pangla, on behalf of our Mazumdar.
as prayed for by MS so-and-so, learned counsel appearing for the petitioner on behalf of Mr. R. Majumdar, learned counsel for the petitioner, comma, list this matter after 3 weeks to enable the petitioner to file reply, rejoinder to the counter affidavit filed by the respondent numbers 1 to 7. Date to deliver. Pension,
may I please, Lordship,
some instruction was required, Mr.
Yes.
Das Gupta.
Yes, they are to file.
my senior is legs before another court, Lordship, may I kindly pass over to.
What was the instruction required?
No, she is a retired bank employee. In the bank, the pension is optional. We opted for pension and it was indicated in our salary sheets all along. Now, after my retirement, my lord,
No,
Pension.
no documents was available.
according to them. No documents.
Instructions has come or not?
Never done.
Why? That is, then we'll have it after some time. Let us find out what is this because
Yes, Lordship, pass over for the.
time being,
Yes, Lordship.
time being, Mr. Das Gupta.
Chocolate.
Yes, Mr. Chaudhary, a promotion.
Yeah, no, my, it is for
Chaudhary?
admission, man.
Huh?
Admission, it is come for admission.
No, that I know. Matter relates to promotion.
Yes, my lord. Promotion and your lordship, this is a third round of litigation, my lord. Your lordship.
Affidavit, what is the position, Mr.
They have not, mind of 3-4 days already, they have taken time, not yet.
The 24 matter, yes.
My lord, the case is covered by a division bench judgment, my lord, because they were regularized. They do not form a part of any cadre. That is why, my lord.
They do not form a,
part of any cadre. Got it? So that is why, my lord, they cannot be promoted to a next level.
why are you not filing your return?
I will file it, my lord.
File your return, give them an opportunity.
Will file it.
They have a right.
The short date we are going to retire, my lord.
By when can you file it? This week?
2 weeks, my lord.
No, 1 week. I'll fix it next Monday,
2 weeks.
Tuesday. You file it in the meantime. If that is your stand, you just have to file a 2-page affidavit. Right. When is he retiring?
That is now, my lord, one year.
Oh, then
Three
there's time.
persons.
All right. As prayed for by Mr. I.
Bottom.
Bhattakur, Learned Standing Council.
PH.
PHE.
PHE, right? PHE, list this matter after 2 weeks to enable the department to file the return in the matter.
In the interim.
Interim, if any, shall continue till the next date of listing. So and so weeks through, on a date.
Date.
Is a Tolot Kodi by list.
Obliged. Number 6.
Mati number 13.
Wait, please, the Lordship.
Silo, yes.
Wait, please, the Lordship. Lordship, I would like to file affidavit in opposition, Lordship, in this matter. We have not filed yet.
As prayed for by MS.
F compliant.
Camprai, Learned Standing Council, KAC, relist this matter after 3 weeks to enable the department to file return in the matter.
Well, date may be fixed otherwise.
List on such and such date.
22nd.
Much.
Obliged.
Supplementary list, item number 24 for orders.
May I please, your lordship, kindly pass over the matter for a time being.
Why?
My
Why
son-
the matter has come for orders? Await service. Relist after 2 weeks on a date to be fixed by the
Yes.
registry.
Item number 25.
No, whatever a batch of literature was pending, that were disposed of finally. So same order may be passed for a petitioner, maybe.
But where is the petitioner?
Petitioner
Mr.
present.
Kaur and none of his team is also here. Shall we have it after some time? Because if you are saying it's a covered matter,
Cover, but
Covered in favor of?
In favor of ballot, he actually in favor of petitioner. Direction was given to the director of secretary to consider their case.
Acha, we'll keep it for some time. In the meantime, you can ask one of your junior to see if any of the
Yes,
listed councils are present in.
no, I will be here. I'll be here. Bless you.
For hearing item number 13.
Part 13 hoy jano. Yes, where is Mr. Nath? I think records.
Yes, madam, they are supposed to produce the records.
Mr. Chutia, can you ask any one of the government councils?
Actually, ballot, part
Yes.
ballot our government representative ballot D. Goda.
No, Mr. D. Nath, I think.
Yes, madam.
D. Nath was supposed to just give the records today.
Yes, that's prototyping ballot.
Yes, I'll keep it for the time being. Just find out. It's only
My lord-
for fixed for our records.
And my lord, we will be relying on a judgment, recent judgment. I'm giving a handover.
What is it? What is it?
On the point that this alternative remedy shall not come in the way of the High Court.
Right.
My lord.
Alternative remedy is one thing.
Because they are saying that the writ petition, we have to go to the criminal court.
No, it's not. You have to go to the criminal
That
court.
I-
You see, it is not like you have an alternative remedy of filing it somewhere.
For the timing, lordship, may have it in
I
paragraph
will,
12.
but what the stand of the department is that these are matter of facts. The grounds that you are taking to assail the sanction, these are all factual matters which can be agitated at the time of trial. It is on that ground they say, and they have relied to decisions
If
of
the
the
lordship
apex
takes
court.
up the
But
paragraph
that's on a
12,
different footing. Alternative remedy is a very settled law that
Paragraph 12,
three
Malak.
contingencies, this court, because these are situation where it is not a bar for this court. These are self-restraints, correct?
self-restraint.
Paragraph
12.
12.
The constitutional powers vested in the High Court or the Supreme Court cannot be fettered by an alternative
Yes.
remedy available to the party concerned.
But
Now
what is the alternative remedy here?
They are saying that the issue as to whether the sanction was proper or not can be gone into by the trial court.
That is not an alternative remedy. You see, alternative remedy means instead of filing a 226, you have a right to appeal.
To delegate to that.
Correct. This is a different situation altogether, Mr. Counsel. Anyway,
Still-
it is just about the records. Let us see. Otherwise,
It is.
I'm ready to pronounce.
Lordship, I see there is some other things is come.
No problem. It's okay. I'm just keeping it for the time being.
Item number 14.
Yes, Mr. Datta.
My lord, in this case, my lord, the person,
Just 1 second, Mr. Datta. Yes, Mr. Nath, you have the records?
I am visiting the record.
Huh?
I am waiting the record. I am not receiving.
But
Lordship is very-
can you have it by 2 o'clock? Otherwise, I'm ready to dictate.
No, you
It's
can-
only that I wanted to have a look at the records. That's it.
Give me one day time. Give me 1 day time. Yesterday was a holiday, but I could not pursue it.
Tomorrow then.
Tomorrow.
Hmm?
Lordship.
Kali pardon? Likho, this is item 13, huh? Mr. D. Nath, request 1 day accommodation to place the records as called earlier by this court by order dated so and so to silo border to. Prayer is allowed, relist tomorrow, date to date for such and such date. Please have it positively, huh, Mr. Nath?
I'll try my best.
my lord, in this case, my lord, charge sheeted officer has since been expired. Now is the legal heir, sir, before your lordships. Now,
What has happened?
my lord, the charge sheet against the charge sheeted officer is, my lord, if your lordship look into page 30. Now, the charge sheet officer in the meantime expired. Now his legal heirs before your lordships. If he gets any advantage, my lord, in regard to the financial benefit, that is only the question. So other things, my lord, whether
What was challenged here? Penalty of reduction of post,
a reversion, my lord.
reduction of post.
Yes.
That was challenged.
my lord.
And in the meantime, what has happened, you said?
He has expired.
He has expired.
Superannuated, then expired.
He has expired, superannuated and expired.
Superannuated, but not after 5 years of superannuation, they filed it.
This petition is filed after 5 years of superannuation.
No, it is not correct, my lord. He was superannuated on, my lord, December, I mean, just 1 minute. Sometimes in,
Sorry. No, my lord, I'm sorry. Superannuated in 2012, but after, my lord, the 5 years.
after 4 months,
After
not 5 years.
5 years of order passed.
All right, let Mr. Datta.
I'm sorry.
Yes.
Now, my learned friend has said after 5 years we have filed. It's not that. He died.
No, 2012 retired.
He retired on 36.
When was
2012.
the penalty date?
Penalty date, your lordship will find.
Just give me the date.
Yes, your lordship will find that at page 40.
19/9/2005.
19?
Annexure 4, my lord.
Hmm. Yes.
The charge officer, your lordship will find based on the records inquiry proceeding.
Page.
Page 40, my lord. Annexure 4. The last para. Based on the records, your lordship has found.
Yes.
Based on the records, inquiry proceedings, careful consideration of facts, circumstances is revealed, and after application of mine, functioning as disciplinary authority of considered opinion that a penalty of reversion, the next lower post of age.
This is dated what? 9?
19/9,
19/9?
2005.
5 or 4?
5 million.
And when did you file the writ petition?
The writ petition filed. Now, this writ petition, my lord, after superannuation, it was filed on 2012. After superannuation, after 4 months, my lord.
No, but penalties of 2005.
Yes,
And you have filed it in 2012.
2012.
There is a big delay.
There is a delay. There is.
What is the explanation? There is a huge delay. Why it was filed after superannuation?
That is
How have you explained it?
that explanation, my lord.
And when was expired? Sorry, Mr. Datta, I'm rushing you to the facts.
No, it's all right, my lord. Paragraph, my lord, for writ petition in 21. Page 18, my lord, para 21.
Yes.
So the petitioner further begs to state that in earlier occasion, he was victimized and implicated on some false charges by the respondent authority wherein the petitioner was punished for alleged loss of sugar while on transit via railways in spite of giving the short certificate by the railways. The petitioner further states that some fabricated and false allegations were brought against the petitioner. The petitioner absented himself from duties, giving others scope to manipulate more stock of sugar during his absence period. Accordingly, departmental proceeding was drawn up against the petitioner and penalty of recovery of a substantial amount from his salary was passed against him. Against the same order, the petitioner had moved this honorable court by filing writ petition being writ petition number so and so. The honorable court was pleased to allow the writ petition by setting aside the impugn order and to refund the amount already recovered from the salary of the petitioner in consequence of the order. Hence, after the reasonable time, the aforesaid order was not complied with. The petitioner had filed a contempt petition being number so and so, but in spite of complying with the aforesaid order, the respondent corporation had preferred writ appeal before this honorable court. Being writ appeal number so and so, against the order of the Honorable Single Judge, but the same had also been dismissed. Even then, a aforesaid order passed by the Honorable Single Judge was not complied with by the respondent authorities. Finding no other alternative, the petitioner had filed another writ petition number so and so, praying for implementing the aforesaid order. The said writ petition was disposed of by order dated so and so, directing the respondents to comply the order passed in the writ petition number so and so and refund the amount recovered from the salary of the petitioner within 31/8/2011. Thus, from the above, it is evident that time and again the petitioner was made the scapegoat for no fault of his in order to harass the petitioner, and the petitioner had to go through several rounds of litigation for getting relief against the respondent corporation. Then your lordship may see paragraph
That
23.
is a different aspect.
That's a different aspect, yes. Now-
Now, para 22, simultaneously department proceedings were drawn.
And in both the cases, the petitioner was penalized for no fault of his. In the instant case, the petitioner's pay scale was refixed to the next lower level till his retirement, and by another order of substantial amount was recovered from the monthly salary of the petitioner for alleged, that is regarding shortage of sugar.
Now, this para 22 is the subject matter in this writ petition.
No, my lord, the subject matter of this writ petition, you also will find. My lord, charge is that in the godown, they used to stack the grains. And there, my lord, your lordship will find in a number of months, your lordship will see that there is a loss of grain, sometimes 2%, sometimes 3%, sometimes 1%. And only in 1 month, it is 15%. And
One second.
that has been.
Yes.
And as per the respondent, my lord, so far the permissible limit of loss is 0.05.
But these are factual aspects,
My
Mr.
lord.
Datta. You see, this court cannot go into all the
Yes,
time.
yes,
This
your
court is not
lordship-
sitting in appeal,
Very
right?
correct. Yes.
Now, first and foremost, it appears that there has been a delay.
Yes.
Undoubtedly, you are before 226, there is no time limit. But
Mm.
if the delay is long and it is unexplained, then of course it is hit by lectures, correct? So first and foremost, you have to show that, because admittedly, the penalty order which is under challenge is of 2005, and you have filed it only in 2012, that too after your retirement.
Yes.
Now, where is the explanation for these so many years? Why have you not challenged this earlier? There is no, this relates to some other facts in para 21.
Yes, your lordship is
This
very
has
correct.
no relation
Is it-
to this. If you are aggrieved by this order, then you should have challenged it. You waited. After your retirement, you are challenging it.
My lord,
And where is you have to show me the explanation, because if there is no explanation on that score alone, this writ petition is liable to be dismissed.
my lord, well, your lordship is right to that respect, but I'll have to see, my lord, whether there is very good reasons, sir, there or not.
Where is it?
Now-
You have to show that.
No, my lord, the only thing in regard to that, my lord, I'll seek just one day time.
For
Hello.
what? This is a matter
Well,
for
it's a-
hearing.
No, I'll see it, my lord. I did not go through all that thing so far this question is
But
concerned.
it is expected that you are prepared for the hearing. This is the basic question, Mr. Counsel.
Yes,
Anyway,
that, my lord,
this court will accommodate you for a day. I'll have it fixed on Thursday.
and so far merit, if your lordship,
Merit, first you
I'll
satisfy
have
the
to,
court
yes,
on delay latches.
get across
It
this.
is apparent. And of course, on merit also, this court has a limited jurisdiction.
Yes.
This court is going to only see the decision-making
So
process,
this is, my lord, I will say. my lord,
whether it is proportionate, not
Yes, yes.
proportionate.
And that is my case.
So
only,
that
my
is
lord.
all, nothing beyond.
Yes, so I'm on that only, my lord. The
Very well, but
penalty
first
imposed,
you have to show
that how I have explained the
Yes,
delay of
an
argument.
explanation. That has to be there in the writ petition, in the pleadings. It cannot be in subsequently somewhere else. You
Yes,
cannot
yes.
find something now and explain. That should have been the
Let me
first
get my
thing.
satisfaction, my lord.
Anyway, as prayed for by Mr. S. Dattal and senior counsel assisted by
Disciplinary.
So and so relist on Thursday.
Obliged.
Number 16.
None appears for the petitioner. Yes.
May it please your lordship. Lordship, the matter relates to termination of a bank employee who was working as a senior manager in Allahabad Bank. Lordship, I'll
Yes.
state the brief facts of the case. Lordship, the petitioner was serving as Allahabad Bank, Guwahati zone as a senior manager.
Since they are challenging the dismissal,
The whole proceeding as well as the impugned order.
he was posted as.
Senior manager, Allahabad Bank, Guwahati zone.
Yes.
From 08/09/2008 to 29/11/2011. Thereafter, he was transferred to the next posting in the zonal office. Lordship, he was served with a show cause notice for the time he was serving as a senior manager, and that show cause notice had more than 100 allegations stating that certain bank norms and documentation such as KYC norms were not complied by the manager. Subsequently, he submitted his point-wise reply to the show cause notice. Not being satisfied, a charge sheet was a charge sheet that lordship may find in page number 16 of the writ petition was served on him. The charge sheet contained 114 allegations. Page number 16. The charge sheet is from 16.
Yes.
The charge sheet is from page number 16 to 62, whereby allegations such as KYC norms and proper documentation were not maintained. Subsequent to that, a disciplinary authority passed an order whereby disciplinary inquiry was initiated. Lordship will find it in page number 108.
Yes.
Lordship, here an inquiry officer was appointed, namely Sri Suresh Chandan Sarkar.
118.
108.
Yeah, 108.
Yes. Annexure 1 of the
Yes.
reply.
Yes.
This is the order whereby disciplinary inquiry was initiated. So in this order, an inquiry officer, namely Suresh Chandan Sarkar, and representing officer Sanjay Vishwas was appointed. Lordship, we have perused the bank records that they had furnished us in the court itself, and we had found letters from both this inquiry officer as well as the presenting officer stating that they are not competent. They had given an application saying that they are not competent and they don't know how the inquiry procedure should be conducted, to excuse them from conducting such inquiry. The disciplinary authority did not take this into consideration.
Who had written?
The inquiry officer as well as the presenting officer.
They both are not competent.
Yes, they
Who has taken
individual
this?
letters.
Who has given this letters?
They themselves have
Themselves.
submitted a letter to the authority.
Which part of the?
Unfortunately, we don't have a copy of this
No,
letter.
where before the inquiry officer it appears that this was not considered.
This in none of they had given us the bank records. We perused that bank records in not even in the disciplinary order, that the impugned order that we are challenging. This is mentioned.
Where in your pleadings you have mentioned?
Lordship, in page number 196.
196 is not your pleadings.
196 is an additional affidavit that we filed after perusing the bank records, and where we found that
Additional affidavit.
yes,
Page
197, if your lordship may go to 197, there is a table.
one nine seven.
Yes, 197.
Yes.
The last column of the table, letter from the inquiry officer.
197 does not have a table. Page 197 is paragraph 3. I think they have been, yes.
Letter from the inquiry
Designation
officer.
has been changed by the office. It's page
Excuse us for the error,
200
we'll-
now. Anyway,
Yes. So they did not furnish us the letter. We were just merely allowed to go through the records. So after going through the bank records, we had submitted an additional affidavit saying that all this document should
so
be
when,
brought on
when did
record.
you get this opportunity of examining the bank records? When were
On
the
1/10/2014.
on?
1/10/2024.
That is while this writ petition was
Yes,
pending.
yes, while this was pending last year in the month of October. We had perused the records and we found out there were two letters.
Mr. Samaria, have you submitted any reply to this additional affidavit?
Regarding that, we have been directed to retain the file, my lord. That file is there, my lord. Therefore, my lord, the records reveals itself whether it is, my lord, relevant with the present proceeding, that is important, my lord. But it is not the part of reading otherwise.
No, that's because they didn't know.
Understood. But the writ
If they
petition,
don't know, how can they plead?
my lord,
It is only when because in paragraph
Lordship,
4 of
can
the affidavit, they have explained that in compliance
Yes.
with the above mentioned
Lordship,
order.
if relevant, my lord, then definitely it can carry bearing, my lord.
You see, the only thing is that if the inquiry officer himself have given a letter saying that he is not he's competent to do the inquiry, that has to be considered.
Lordship, the letter says something else also, my lord.
Show, give me.
They have only, my lord, they are not raising any allegation. They are just bringing on record. That's why we have not responded, my lord, because records is.
No, but it's a serious thing because from this column, which appears at page 200, it says in this letter, the inquiry officer admits to the Deputy General Manager, Zonal Office, that both he and the presiding officer lacked any prior experience or formal training in conducting disciplinary proceeding.
Lordship, a letter from presenting officer was also submitted.
Report. I have to like more.
How have you dealt with this letter? How have you dealt with it?
Well, this letter that has been by the part of record, what he has stated about that, he said that he has known him, my lord, prior experience of formal training, my lord.
How have you dealt with it?
But because, my lord, we
You
felt.
see, it is not, this is not the answer which you will be giving to this court. You have to show it from the record, how the department has dealt with this letter. Because at the end of the day, it is the fairness which has to be seen, right? The opportunity, natural justice, these things cannot be given a go by. Now, in this letter, and it appears that a huge number of allegation charges have been framed. Right.
Yes.
Now, if an inquiry officer is appointed, it is obvious that that person has to have some basic knowledge. Correct. Now, here he himself is saying that
Formal training.
sir, myself and so PO both are holding the first line charge of two so, looking the vital task of overall business development and recovery of NPA assets of the branch. Moreover, both of us neither have any past experience of discharging the jobs of PO or EO, nor any sort of training in this regard. Have been given to us till date. Matter has been personally brought to your kind notice earlier. So all this court wants to know. You see, Mrs. Amaria, all that this court wants to know, how have you dealt with these letters? You have to indicate.
Definitely.
You see, now this point has been raised by Ms. Agarwal,
Gupta.
Gupta. The court cannot since because the department ignored these letters, now this court sitting in 226 cannot ignore it. The court has to answer it, right?
Only point out
Yes.
that so far this letter is concerned, it is confined to two issues that he doesn't have any formal training.
Whatever be it, you have to deal with it.
Just I have received the
Because
record,
you see, it also says matter has been personally brought to your kind notice earlier. That means this is not the first time. They have been telling you all that we lack experience, we lack training. Now, how have you dealt with it? It's a sensitive matter. So many allegations, so many charges are there.
The
What
same-
have you done? Because you have to show that you have considered it.
Right.
Whatever the reason is,
Yes.
but something must be there, isn't it?
Lordship, give me some time because my lord, just now I have received the records.
You examine it. If
And I
required,
also consult with
you
my-
file a reply to that additional
That's fine.
affidavit and you put your stand on record. Otherwise, how is this court going to, do you expect this court to now look into this voluminous file and find it for itself? Where are these letters? You have to
I will
assist.
respond, ma'am.
Lordship, we had furnished this affidavit to them in the month of October.
That's all right, Ms. Gupta.
A small date
Uh,
could be fixed.
It took right here. As prayed for by Mr. S. Samaria, Learned Counsel, appearing for respondent number 1 and 2.
1 and 2, ma'am.
1 and 2, relist this matter at a date after 2 weeks on such and such date to enable the respondent to file reply affidavit to the additional affidavit filed by the petitioner on 7/11/2024. It is
Lordship,
needless to
no.
be clarified that since the matter pertains to the year 2015, no further accommodation in this regard shall be given to the respondent to file the clarification affidavit as is required.
Right.
You want to say something more, Ms. Gupta?
Lordship, I was requesting that if they could bring the documents that we had asked for on record, it would be better to adjudicate the matter.
All right.
My lord, I am extremely sorry. I was on leg and put number 4. And my matter is, my lord, item 24. On 30th April, he is retiring, man. So extremely urgent matter.
Item number?
Item number, my lord, 24.
24, the notice is not served
My
as
lord,
of yet. I think await service.
My lord,
You
30th, on 30, I am going on retiring.
But how the matter, contempt matter can be proceeded when the service
procedure
is not
to the-
complete?
When your lordship may take some strict matter, then they will dispose of my,
Anyway, we've
application.
already passed the
there is the
order.
order of the court, man.
Yes,
Item
Next.
number 17.
Lordship may kindly,
Lordship,
for the time being.
I need certain instruction with regard to the matter because this relates to
1 second.
Lordship. On the accommodation of 1 week will, when a date may be fixed.
You want Mr. Dekar, right?
Yes, Lordship.
Yes, what do you want?
I want said 1 week time to come back with certain instruction which I saw, which I haven't got as yet, Lordship.
All right. How much? 1 week?
1 week, Lordship, any date may be.
As prayed for by Mr. D. Dekar.
Yes.
D. Dekar,
Yes, Lordship.
Learned Counsel for the respondent number
5 and 6.
5 and 6. The matter stands adjourned to such and such date to enable the respondent to obtain the instruction as required in order to file affidavit,
No affidavit, Lordship. We'll have to come back because I've newly engaged.
to obtain the instruction as required.
Lordship, can you fix it date? 22nd May. You oblige.
Item 18.
Yes, Mr. Roy, this is area salary,
No, my lord, no salary. In
no
fact,
salary.
my lord, in fact, they,
Since when?
no, my lord,
Today's for what happened actually.
the lordship will kindly see the last
One
one.
sec.
25, I took time for filing affidavit.
Uh-huh.
To file affidavit, took time, my lord, on 25th March 2025.
Yes.
Today, now, you holiday has gone, my lord. And now, my lord, today, director has come, he was out of station, and today they are sending the affidavit.
The
that
who
means-
and all that is fine, but this person has not got salary from,
My lord,
Since-
for months, they are the double,
since
employee.
when?
My lord, for 15, 16 months, my lord, they are not getting the salaries.
So let me file the affidavit today, I will file it.
All right, Mr. Shutia has given an assurance. Mr. T.C. Shutia, Learned Additional Senior Government Advocate, Assam, assures the court that the affidavit in opposition shall be filed positively by,
During the course of time,
positively today,
positively.
positively be filed during,
2 days.
within 2 days from today. In view of the aforesaid assurance, relist this matter next Monday, such and such date. Tuesday corridor.
Lordship, I'm appearing for respondent number 8.
All right.
Item number 19.
Kindly pass over the matter for timing.
Time being.
It's on legs. Much engagement.
All right, I'm about to finish the board, but
Yeah.
anyway, we'll see.
Ready when they are.
All right, yes.
Item number 20.
Yes,
May I please, your Lordship?
refixation of pension.
Lordship,
Yes, what is your grievance?
My grievance is,
You took time to file reply. What happened?
no, sir, reply not required,
Huh?
Lordship. Reply not required.
Not
Lordship.
required.
Not required, Lordship.
Yes. Yes, Mr. Talukdar, what is the case?
Lordship, my case is that, basically my case is that I have two parts of services. One as adult supervisor adult education, Lordship, and thereafter, Lordship, project officer, Lordship. While calculating the pension, only the length of services rendered as project officer were counted, Lordship. Earlier part was not counted, Lordship. This is only my case, Lordship.
What happened?
Lordship,
While considering
Lordship, I have two parts of services.
parts.
Two services, Lordship. One is, Lordship, supervisor, and other is, Lordship, project officer.
What do you mean by two parts? You are holding two posts.
Post, Lordship.
Post.
Two posts.
Yes.
Not
One
initially,
is supervisor and the other one is?
Lordship, initially I was appointed as supervisor, Lordship, in the year 1981, Lordship. Thereafter, Lordship, in continuation to that, Lordship, I was appointed as project officer under the same department, Lordship. And Lordship, I got retirement from service, Lordship. As project officer, Lordship. As project officer, Lordship, and accordingly my pension was censored.
You retired when?
Lordship, Lordship, got retirement on, Lordship, 28 February 2011, Lordship.
21 February.
28 February, Lordship.
28/2/2011.
2011. 2011.
Yes. And you retired from the post of
Project officer, Lordship.
project officer.
Project officer, Lordship.
You were also holding the post of supervisor.
Supervisor. Initially supervisor, Lordship.
And from supervisor, you got transferred.
Lordship, not Lordship. Promoted, Lordship.
Promoted.
Actually, that was fresh appointment, Lordship, under the same department, Lordship. Lordship.
So then,
Now, Lordship, may kindly come to the PPO, which is at page 25. Page 25.
yes.
Relevant part is at page 27. Lordship, here date of appointment, my date of appointment was considered as 22 March
This
1991.
is to the post of project officer.
Project officer, Lordship.
But you said it was a fresh appointment.
Lordship, in continuation to the earlier post, Lordship. Lordship, Lordship, may kindly have a look at my release order.
1 second.
Release order is
First, you show me the advertisement for the post of project officer.
Lordship, I have not
You applied, isn't it?
replied.
And you applied pursuant to some advertisement.
Lordship,
Where is that advertisement?
I have not got that, Lordship.
Huh? What is the stand of the respondent? What is the stand of the respondent, Mr. Talukdar?
Yes, the stand is that, Lordship, my earlier services were, Lordship, fixed contractual service, Lordship. And that is why that part was not counted, Lordship, while calculating the pension.
Where is it? Paragraph 5.
Paragraph 5, Lordship.
Yes, read.
That with regard to the statement made in paragraph number 2 of the writ petition answering deponent begs to submit that petitioner was initially appointed as a supervisor under the National Adult Education Project by an order height memo number so dated so on temporary basis in a fixed pay of rupees so only per month for the period up to 31st/12/1981. Accordingly, the petitioner joined the service on 5/12/1981. Subsequently, government by notification number so dated the petitioner had come under revised fixed pay. It is not relevant, Lordship. The appointment of the petitioner as the supervisor was on the basis of fixed pay and on purely temporary basis. Therefore, the post of supervisor cannot be considered as substantive post, Lordship.
You are Jyotish Pathak.
Jyotish Pathak, Lordship.
The appointment order is at page 10.
Page 10. Initial appointment is page 10.
Subject to discharge without notice and without assigning any reasons.
Lordship.
So it's a purely temporary appointment.
Temporarily, Lordship. But I continued, Lordship, without any break.
No, you were not regularized to the post of supervisor. You subsequently applied in view pursuant to some advertisement, correct?
Lordship.
All right, para 6, read. Let us finish the affidavit.
There are 6, Lordship. That with regard to the statement made in paragraph number 3 of the writ petition, answering deponent begs to submit that thereafter, by memo number so dated 18/3/1991, the petitioner was temporarily appointed as project officer under the adult education program in the scale of pure rupees so plus other allowances.
And you never challenged all this, these two orders. Let's see this. I've read it. Sorry, Mr. Talukdar, I went a little fast. The annexure 2 at page 11.
Lordship.
Read page 11.
Page 11, Lordship.
So you were initially appointed temporarily as project officer.
Project officer, Lordship.
And your serial number 14.
14.
Subsequently, you have been regularized by the order at page 12, correct?
Lordship.
Read.
This is service book, Lordship. This is service book.
Okay, but
Service.
read, the following persons are appointed temporarily as project officer and as per recommendation of so and so.
The following persons are appointed temporarily as project officer under adult education program.
So where is this order of 27 whereby you were confirmed?
Confirmation order is at, Lordship, in my
Yes.
writ petition, that is.
No, I think this 27, page 14.
Lordship. 14, Lordship.
Yes, you were confirmed with effect from so and so against the post of project officer.
Lordship.
Now you have never challenged all this.
Lordship.
What case do you have? What case do you have, Mr. Talukdar?
Lordship, my contention is that, Lordship, my earlier services were also
That
substantive.
is not to the same post. You were appointed on a temporary basis to a different post.
Lordship.
You were not regularized in the post of supervisor.
Lordship.
Subsequently, you applied to
Lordship.
the post of project officer,
Lordship.
to which you got appointed initially on temporary basis. Later, it was confirmed in that post.
Lordship.
And accordingly, after your retirement, you have been given pension to the in respect of that post till that period. How now you can say the past the service in the post of supervisor which was not confirmed? How are you entitled?
But Lordship, I rendered more than 10 years services. Lordship.
Then why did you not challenge the confirmation order, which says confirmation to the post of project officer? Why did you not challenge that order? At that time, you could have come before this court
Lordship.
and taken a stand. You waited, knowing very well. Yes?
Lordship, but I rendered, Lordship, more than 10 years of services, Lordship. And in continuation to that, Lordship, I was appointed as project officer, Lordship, which reflects from the release order, Lordship. Lordship, may kindly come to the page number 21.
The only problem is that your supervisor post was never regularized because
Regularized, Lordship.
under Rule 31,
Lordship.
it
Under-
has to be for substantive and permanent.
Lordship.
Supervisor was never confirmed. Sorry.
Lordship.
Yes, what do you have to say?
Your Lordship, we have already stated in an affidavit in paragraph number.
So that's all?
Yes, Your Lordship.
You don't have any submission. You leave it to the court to read the everment. Then? What is your stand?
This
If that is the stand of the government that we have filed an affidavit and that's it, then why
he
the
was appointed as
hearing?
a non-pensionable, Your Lordship. And the advertisement, the petitioner has not challenged that advertisement, Your Lordship.
Where is that advertisement?
Yes, not the next advertisement. Your
Do you have a copy of the advertisement? Mr. Chalya, you are in this matter?
The main issue is Lordship, the post for which he is claiming his benefits for Lordship. As per whatever I could see from the education, that was a temporary post. And they have clearly stated also that the person will not be entitled to pension anyway. And then comes a new appointment, Lordship, on the basis of it. From that day, from that point, they have given the pensionary benefit, Lordship.
And that confirmation is clear.
Yes, Lordship.
Confirmation to the post of project office, which he never challenged.
Yes, Lordship.
Rules called person. Assam Service Pension Rules.
10 years also he has not entered in the
Temporary
post. It's not completely 10 years.
Then it is completed.
How much period he was there in the post of supervisor from?
From 5/12/81 to 12/81 to 21.
12/81
Yes.
to
21/3/1991.
21/3
1991.
1990
1991. Lordship,
22/3.
22/3/1991. So that is also not completed 10 years.
Lordship, yes, in the court record, in the affidavit of the education department is 22.
This affidavit which I'm presently looking at, this is filed by the education department. And the relevant rule is 31.
31.
Please take down. Heard Mr. H. Talukdar? HK Talukdar, right?
H. Taludala.
Huh?
H. Taludala.
H. Talukdar, learned counsel for the petitioner. Also heard MS.
H. Terangpi, Your Lordship.
H.
Terangpi.
Paisa. The learned counsel appearing for respondent number
1, Your Lordship. 1. Only 1.
1. Mr. A. Chalia for learned counsel appearing for respondent number 2. What about 3, 4, 5, 6?
I will appear for that, Your Lordship, for 3, 4 and 5.
Executor 3, 4, 5 corridor. 6, accountant general. Anyone for accountant general?
Normally, R.K. Talukdar appears, Lordship.
He's not here. None appears for respondent number 6 when the matter is called. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking mandamus in the nature of seeking a writ in the nature of mandamus for direction to the respondent authorities to calculate the length of service of the petitioner as supervisor under National Adult Education Project towards qualifying service of the petitioner for pension and other retired benefits. Stop. The brief facts of the case is that the petitioner was appointed initially as a supervisor under National Adult Education Project by an order dated 26/11/1981. On temporary basis. Accordingly, the petitioner joined the said post on 5/12/1981. Later on, the petitioner was appointed temporarily as a project officer under the Adult Education Program by an order dated 18/3/1991. Stop. The petitioner was accordingly released from the post of supervisor, and thereafter he joined his new assignment as project officer on 22/3/1991 by submitting his joining report and also submitted joining report thereof. Thereafter, the services of the petitioner as project officer was confirmed by an order dated 27/7/2012. Thereafter, the petitioner retired from service upon attaining the age of superannuation on 28/2/2011. Upon superannuation, where is that pension that was released to you? There is any order?
Page 25.
Page 25
Page 25.
of the 27, I think.
27, Lordship, 11.
The petitioner was given the pensionary benefit from the date from 22/3/1991, i.e., the date of appointment to the post of project officer. It is the specific case of the petitioner that since the petitioner was initially joined, it was initially appointed to the post of supervisor in the same department, in the same scheme, right? Under the same scheme.
Scheme, Lordship.
And he continued in the said post without any break. Situated thus, the present writ petition has been filed. Thereafter, you say, Mr. H. Talukdar, Learned Counsel for the petitioner, submits that since the petitioner was initially appointed to the post of supervisor in the same under the same scheme, which he continued without any break of service till his appointment to the post of project officer, which was later on confirmed, he is entitled to receive pensionary benefit and other retired benefits from the initial date of appointment, i.e., 5/12/81 from to the post of supervisor. Stop. Per contra, MS so and so, Learned Counsel for the respondent for the respondent education department, submits that since the initial appointment of the petitioner to the post of supervisor was temporary and the same having not been confirmed, the petitioner is not entitled for any pensionary benefit in respect of his service rendered in the post of supervisor. She further submits that the petitioner having appointed to the post of project officer after being selected pursuant to an advertisement, comma, and his services to the said post of project officer having been confirmed, he is entitled for pensionary benefit only in respect of the services rendered to the said post of project officer. Stop. Mr. H. Elia, learned so-and-so, also submits that it is apparent from the affidavit in opposition filed by the education department that the petitioner has not even served 10 years in the post of supervisor. That apart, he submits that the services of the petitioner having not been confirmed in respect of the post of supervisor, he is not entitled for any retired benefit in this regard against the said post. Stop. Right? It appears that the petitioner was initially appointed to the post of supervisor under National Adult Education Project on a temporary basis by order dated on 26 1981. The date is 5/12/81 or 26/11/81?
Lordship,
26/11/81.
26/11, Lordship.
Yes. Huh? On a temporary basis in a fixed pay of ₹500 only per month for the period up to 31/12/1981. It further appears that the petitioner joined the said post on 5/12/1981 and subsequently on 6/12/1990 his pay was revised to ₹875 per month. Stop. It further appears that pursuant to an advertisement for the post of project officer in the adult education program under the National Adult Education Project, comma, he applied for the said post and by order dated 18/3/1991, he was temporarily appointed as project officer. Apt to reproduce the aforesaid appointment order, which is hereunder, quote unquote, page 11. It appears that subsequently the petitioner on 22/3/1991 joined the said post of project officer, and later on, by order dated 27/7/2012, the service of the petitioner was confirmed with effect from 27/2/2011 against the post of project officer. Stop. Apt also to reproduce the confirmation order dated 27/7/2012, which is hereunder, which is reproduced hereunder, quote unquote, page 11. A reading of the what transpires from the above is that initially the petitioner was appointed as supervisor on a temporary basis, and subsequently, after participating in the selection for the post of project officer, the petitioner was appointed on temporary basis to the said post of project officer, which was later on confirmed. It further appears that the petitioner has not challenged the aforesaid confirmation order dated 27/7/2012, reading of which it is apparent that the service of the petitioner was confirmed only against the post of project officer. It appears that accordingly, after the petitioner retired on 28/2/2011, retired on
Lordship 28/2/2011.
on so and so, comma, the pensionary benefit was given from the date of appointment to the post of project officer. Stop. Apt to refer to the relevant paragraphs of the affidavit in opposition filed by the respondent number so and so, Education Department, quote unquote, paragraph 6. Paragraph 5, 6, 7, 5, 6, 7. Page 30. Reading of the aforesaid paragraphs, it is further apparent that the pensionary benefits of the petitioner was given from the date of his appointment to the substantive post. This court finds the aforesaid fixation of pension from the post of so and so appears to be also in conformity of Rule 31 of the Assam Services within bracket Pension Rules 1969, apt to refer to so and so, which is quoted hereunder, quote unquote, Rule 31. Reading of the aforesaid provision of law, comma, it is apparent that in order for a service of an officer to be qualified for pension, comma, the employment must be substantive and permanent. One of the one of the condition essential is that the service must be. Okay. Stop. Admittedly, in the present case, the initial appointment of the petitioner to the post of supervisor cannot by any stretch of imagination be considered to be substantive and permanent. That being so, this court finds no infirmity. That being so, this court finds this court is of the considered view that this writ petition lacks merit. Accordingly, writ petition stands dismissed, no cause.
Number 21.
To time low and asil jala prathame.
I'm appealing. On behalf of Lordship, I'm appealing on behalf of S. Dutta Lordship. I'm seeking for adjournment.
On what ground?
Due to personal difficulty, it would not come to the court order. Due to personal difficulty, it would not come to the court order.
Your MS
P. Thapa Lordship.
for
S. Dutta, PNRD.
learned as prayed for by MS so-and-so, learned counsel appearing on behalf of the standing counsel PNRD, will relist this matter after 2 weeks on a date to be fixed by the registry.
22.
May I please, your Lordship?
Yes.
Lordship, the matter relates to re-engagement of the petitioner as data entry operator.
MR worker.
Yes,
Lordship, no,
work chart.
Not the MR worker, Lordship. He's the one for piecework based on various project, Lordship. That's only MR is different, Lordship. He's not the MR worker.
Matter is ready for hearing?
Yes. Lordship will, this is the third round of litigation.
Yes, Mr. Fukan.
I'm for the 1 and 2.
This is the third round of litigation. Lordship will kindly have a look at the order at page 53, first round of litigation. Order at first round of litigation. 53. Facts is also laid down and also the
Lordship.
Yes.
Lordship, there is an order, Lordship, on 28, Lordship, 10, Lordship, 2024. The record is sort of.
Oh, you don't have it?
Yes, Lordship.
Which order?
28, Lordship. At 28.
Yes. All right, as prayed for by Mr. J.K. Goswami, learned additional senior government advocate, relist this matter when?
2 weeks, Lordship.
After 2 weeks on a date to be fixed by the registry to enable the respondent to produce the records as called earlier by this court by order 28/10/2024.
Time being adjournment.
Yes.
Lordship, the instructions is still awaited.
Yes, how much time do you need?
Only one.
Hmm?
Only one. Basically, our claim is that we have not received any pension form in the personal department of the head office.
You file it, whatever you instruction you need to give.
Already, your Lordship, affidavit in opposition has been filed. But in the order dated.
Yes, I have seen Mr. Dasgupta has already taken me through that. Because your one of your instruction is that no document was available.
Yes. No document was available. No document was submitted.
Anyway, you complete your instructions and in fact place it by way of an additional affidavit so that they get a chance.
Yes, if I could find, yes.
Mr. Dasgupta?
They have filed their affidavit. According to their stand in the affidavit is that
No document.
no, that is not. The option was not in proper form.
Not in proper form.
Now there is no good.
Anyway, let him take the instruction because there's a judicial order already.
They have filed their affidavit also.
This is.
That
is
affidavit
on record.
was filed earlier
So, Lord.
on 21, on 11/11/24, and this order is of 13/3/2025. Correct?
Yes.
Where it says so and so submits that he is yet to be instructed on the status of any documents being available in so and so.
In the
He
personal
therefore prays for some times to complete his instruction in respect of availability of so and so. So let him complete it. As prayed for by Mr. M. Sharma,
Yes, Your Lord.
learned counsel for the respondent, release this matter after
1 week.
1 week on a date to be fixed by the registry to
No,
enable.
the Lordship may kindly fix a date.
All right, on a date on such and such date to
Or
enable
it
the
may, maybe 2
respondent
weeks after,
to
no
file,
problem.
to place the instruction as called earlier by this court by order dated 13/3/2025. On top to me, I've heard Mr. A. Das Gupta and senior counsel assisted by Mr. So and so learned counsel for the petitioner, and also heard Mr. M. Sharma for respondent number
125.
125 and Mr. Medhi
6.
S.K. Medhi for so and so. তাৰপিছত লিখি দিবা so and so praised.
Can it be on 6? Can it be on 6? Any of this?
Yes.
Item number 19. They were in court.
Yes, I have seen Mr. Kaur, I think, yes, Mr. Singh.
Lordship, he's on legs, my lord.
Huh?
He's on legs, my lord. Pass over for the timing, my lord. Next matter.
It will last matter in narrow set. All right, let me take the other matter. Mr. Khanna, wait.
Malas.
Item number 25.
If I may, my lords.
If I have to supplement it.
In this matter, my lord, has been is heard by the judgment at the main case
Yes.
of the Arjun Das case.
A writ petition. What is IA, Mr. Singh?
Lordship, we have filed this IA because at that moment, Darpan portal was open and I was not let admissions in that portal because I'm not a provincialized school. But all these years, I've been taking admissions for class 11 by feasibility report and the NOC accord that has been granted to me by the government. So my main contention was, my main writ petition prayers are for provincialization of the services of petitioners and the non-teaching staff and the school as well, my lords. Now, the Act provides that for a school needs to have 25 students at minimum to be under the category to be provincialized. So all these years I've been maintaining those 25 plus students in my school. And eventually when I went for to the authorities for provincialization, they rejected my prayer. And hence I'm before this court, my lords. My IA was that for a brief period, when they let admissions open in the portal, I be admitted and I be allowed to take students on board, because all these years I've been doing it. And this writ petition has been pending for a year, my lords. And last year also, by the order of this honorable court, I was let open in the portal and let to get admissions on board students. And as well, I have done 51 students onboarded last year. This was the prayer in my IA. My lord, those dates have elapsed now in my IA. I have filed an additional affidavit in my main writ petition.
IA otherwise has become infractious.
My lord, I would not say that because there's another notification that has come subsequently, because there are 3 stages in which I can onboard students. First was if I be allowed to go to the portal and I enroll myself as a school, and then all formalities are done, I can start onboarding students. Second comes when the admissions happen and the results are out, that is this period. Now I can again go to the portal and get the students onboarded. This is the second chance I am having, my lords. And tomorrow is the last date for that students' admission to be closed again.
So this is session for 25-26.
Yes, tomorrow
the
is
matter relates to session 24-25. In fact, petitioner also get admission ballot in the portal by virtue of the interim order of honorable court in the Arjun Das case ballot. 24-25. 25-26, he is not otherwise eligible to 24-25 also. Now 25-26, he is not at all. Now this direction is given by the by this order ballot, considered by the director their cases. All documents, all readings are same to the Arjun Das case, because Arjun Das case is ballot reading case. The
This-
same matter.
What
So
is
what
this?
he's saying, I don't understand. But the portal is 25, 26. He's
What
not
is
entitled.
this Arjun Das case?
This one.
Arjun Das, yes.
Yes, I have a copy. In fact, I think both of you have given copies.
My lords.
Oh, no,
There
my
are
lord, I
two
have-
copies.
Yes, sir.
Yeah.
Why
Yes.
this is relevant is
And now,
because
my lord, instead of filing the reply in our affidavit, they are filing additional affidavit. What does it mean? What does it mean? Why he is filing? I don't understand.
Anyway, we'll see to that, Mr. Chutia. Let first Mr. Singh complete.
my lord,
Yes, Mr. Singh, what is what do you want to show from Arjun Das case?
my lord, these were similarly situated schools, and they were allowed to get admissions to the Darpan portal, and this case allows them to get admissions of the students. That is why this was a covered judgment
This
in our
matter
case
has been
also.
disposed of.
My lord.
What is the operating? Let's read
My
the
lord.
operating paragraphs.
My lord, may kindly be on 34 and 35 para number.
33.
34 and 35, my lords, if I may read.
Let's start from 33.
33.
Why don't we start from 31?
Very
On
well.
perusal of, let me also have a grip of the matter because yes, 31 on perusal of the
Yes.
records.
On perusal of the records, it is found that the petitioners have applied for permission with requisite records to the appropriate authority. As noted above, since the council-wide notification dated 1/4/24 had notified that the case of the non-permitted private institutions which have applied for the permissions with relevant records will be verified and may be allowed to conduct admissions if the relevant records are found in order. I am of the considered view that there is no reasons as to why the institutions of the petitioners, for that matter, the case of the petitioner shall not be verified and allowed to conduct the admissions and pass constitutional orders as the institution schools of the petitioner appear to be feasible for permission to be accorded to conduct admissions for higher secondary first year class and onwards.
So this part in
Yes.
the present case, Mr. Chutia, there is
No, but same thing, my lord, because he is saying has paid his.
Mr. Chutia, just please appreciate that I have no idea of the facts. You both have it. My simple question to
Simply, I'm briefing them, my lord.
yes,
The
but no,
petitioner cases, my lord.
One second, please bear with the court. All I am asking is that as far as para 31 is concerned, this present petitioner is also similarly situated.
Similarly situated.
All right. Yes, please
Yes, if I may
proceed.
continue, my lord. Para 32. The respondent, ASIC, has made a categorical stand that if the permission is granted by the government, the ASIC would not have any objection as the according granting of permission is with the authority of the government and not with ASIC. If that be so, since the petitioners have applied for permissions to the respondent authorities, I am the considered view that the respondent authorities are deserved to be directed to consider the case of the petitioners in accordance with the regulations relating the issue of granting permissions to the schools
So if
of the
this
petitioner. Yes.
That is direction to the TSC.
correct. So
Unless they have given a permission.
understood. So you have no objection if this order is passed.
Yes.
Para 32.
If
Yes.
the-
Read further.
Further, my lord, para 33. Although the petitioner have also prayed for a direction to complete the process of provincialization of services of the petitioners under the Assam Education Provincialization of Service of Teachers and Reorganization of Education Institute Act 2017, as amended in 2018, the court refrains from determining the said prayer as the same would be consequential to the decision or order that would be taken or passed by the respondent authorities as would be directed. Therefore, present determination is confined to the issue of granting permission. As the petitioners have not particularly pressed the above grievance at the time of hearing, however, it is observed that the above grievance would be consequential to the granting of permission by the respondent authorities, and the petitioners are at liberty to renew the same if need arises at the appropriate stage. 34 continued, my lord. In view of the following discussions, I am of the considered view that the respondent are deserved to be directed to consider the case of the petitioners for according permissions and allow the conduct admission for higher secondary first year class onwards in their respective schools. 35. Accordingly, the respondent authorities, namely the Secretary to the Government of Assam, Secondary Education Department and the Director of Secondary Education Assam, as well as the ASIC, are directed to consider the case of the petitioners within a period of 3 weeks from the date of receipt of the certified copy of this order. And 36 continued, my lord.
You have any grievance if this order is passed?
My lord, my only prayer today is that if my writ petition not be heard at length today, then I be allowed to be enable myself to open in the portal of the.
Why should this court go into that aspect? This court can simply dispose it off in the similar line.
Yes, my lord.
And direct the respondent authorities to consider the case of the petitioners within a period of 3 weeks.
Exactly, my lord.
Why,
lord.
all right, you think of it, I'm coming back in 5 minutes.
Yes, my lord.
Yes. The main thing is, my lord, when you see the regulation, my lord, on the basis of that regulation,
Which regulation?
our regulation, the council regulation. That's why director was given by them.
No,
What-
Mr.
Paragraph-
Kaur, I was just simply asking Mr. Singh that can this matter be disposed of in the similar line of Arjun Das?
There is actually one difference
Yes.
is there. In those cases, permission was not there. Ours, prior to that date, the permission was there.
In your case, permission was there.
Yes.
So therefore, that direction is meaningless
Yes.
because
No,
you
no.
already have permission. Is that what you're trying to say?
My lord, if I may draw my lord's attention to
Right.
paragraph 24 of the judgment.
No, there is no permission, my lord. Lordship, kindly see paragraph 3.
All right, Mr. Chutia, 1 second. You just take your seat. Let me just finish the petitioner first.
Yes.
Where is the prayer? Page 12.
Prayer of my writ petition, my lord.
Yes.
Yes, my lord. Page 28 and 29, my lords. Of my writ petition.
Page 28.
28 and 29, my lords. Starts at 28.
Yes.
Yes.
Read
Yes, my lord.
the operating part.
My lord.
To provincialization their services.
Directing the
Yes.
respondent authorities, more particularly to consider the case of the petitioner. So this is what you're seeking.
Yes, my lord.
So if the direction is given to consider,
No, my lords. Why is it different, my lord? That the act says that I need to have maintained 25 minimum students every year to be eligible.
But first of all, he has to obtain the permission. Lordship, kindly see the
My lord,
regulation.
my
There are
permission
Mr.
come-
Chutia, you're not allowing
No,
the
no, that's what-
petitioner to submit. Let him submit first.
No, he is not agreeing with the by the
Mr.
disorder.
Chutia, I'm going to hear you. I'm not going to pass a judgment without
No, no,
hearing you.
So why I am pointing out Lordship to understand.
Let us give opportunities
Yes,
to the
yes,
young
yes.
lawyers to argue.
Yes.
What is wrong? He's arguing his case. Yes, Mr. Singh.
Yes, my lord. My lord, the act says that, if I may draw my lord's attention to the act, 25 number of minimum students I need to have every
Which
year.
act?
The act, Assam Education, Provincialization of Services of Teachers and Reorganization of
I
Education.
don't have that act.
There's 17 act, my lord.
Are you holding the same book?
Yes, my lord.
Which page?
Page 109, 108 and 100.
Edition.
Shorter version.
Huh? 119.
108 and 109, my lord. Yes, it might differ, my lord.
Okay, it's different. What is it called? Assam?
Assam Education, Provincialization of Services of Teachers and Reorganization of Education Institutes Act
Teacher.
2017.
All right, all right. 2017.
17, my lord.
9. Yes. What do you want to show from here?
Section 3, my lord. Subsection 1.
1 second. Yes.
Section 3, subsection 1.
Section 3, subsection
1.
Yes, please read.
If I may lead, my lord.
Yes.
The venture education institutes which have been established and have obtained the required permission, recognition, affiliation, concurrence as the case may be required for the concerned institution from the respective competent authority or authorities on or before 2006, my lord. This says that. And now if I may draw my lord's attention to
Well, it means that the venture education institutions which has been established
Yes.
and obtained the required permission.
permissions
So and so
prior to 2006.
1 that is the cutoff date.
Yes, my lord.
Yes.
Now, my lord, my permissions, my lord.
Yes.
And my additional affidavit also has a feasibility report pursuant to which I obtained permission.
According to you, you have already got this before 1/1/2006.
Yes, my lord.
Where is it?
Right, page 41, my lord. Annexure 2 of my writ petition.
Page 41.
41, my lord.
Yes.
My lord may see the date 26 July 2005, which is prior to 2006, my lord. If I may read, my lord.
Yes.
With reference to above, I am directed to inform you that government is pleased to accord permission to open first year high secondary class in art stream in respect of Dongawari High Secondary School, Morigaon, subject to the fulfillment of all conditions, on condition that government will not bear any financial liabilities in future for the permission accorded. So, my lord, permission was accorded to me in 2005 itself for opening class +1, that is higher secondary first year.
26 July 2005.
Yes, ma'am.
Yes.
Accordingly, my lord, I have been onboarding students all these years to fulfill the criteria that the Act lays at subsection 5, 3.5, my lord. If I may bring, my lord, 3.5.
Yes.
Yes, my lord. It's, if I may read, my lord.
Yes.
The venture education institutes.
Minimum 25.
Yes, yes. For class 10. If it's a venture high school, 25 students in class 12. If it's a venture high secondary school or a venture junior college, 30 students in the final year or 3-year degree course. If it is venture degree college, as on the date of coming into force of this act. So, my lord, I fall into the 25 criteria.
You are a
I'm a high secondary school.
venture
High secondary
school.
Yes.
So you know, in case all right. So 25 students.
Yes, ma'am. Accordingly, all these years I've been maintaining above 25 students.
Where is that paragraph?
My lord, may kindly be with me on page 46, annexure 5. It indicates the student strength of my school.
Yes.
This is a school report, my lord.
Yes.
To the Director of Secondary Education. If my lord be on page 47, the next very page.
Yes. 46, 47.
46, 47.
The chart.
Yes, my lord.
Yes.
Under the column serial number 5.
Yes.
Enrollment in the highest class, class 11. 3.5, under the 3.5 that I read just now, my lord, the 25 student criteria.
41,
So 2014,
40,
15, 16, I had 41, 40 and 42 students respectively.
Yes.
Yes, my lord. Accordingly, after that, Inspector of School has also given us a report where 49 and 50, yes, where I have been maintaining.
Where is that?
Page 49, my lord, annexure 6. Yes. There's an enrollment of students who appeared in HS final examination in the years 2014, 15, 16 from Dongawari High Secondary School. The report is next page, my lord. Total students 41 that have appeared. So, my lord, why I'm indicating these pages to show that 3.5 has been fulfilled by my school and 25 number of students has been enrolled each year, more than 25, and I've been fulfilling the 3.5 criteria. Thereafter, my lord, 58. Yes, ma'am. Under annexure 7, page 58, if I'm, my lord, maybe on page 58.
58.
Yes, my lord.
Yes.
This is the council's report to the principal of Jagir Road High Secondary School. Again, indicating 2014, 15, 16, and 17 total enrollments of students, my lord.
Yes. More than 25.
Yes. Yes, my lord.
But these are in which grade?
Class 11, my lord. Subsequently, they passed class 12 also.
No, in this page 58, where is it mentioned? Class 11?
My lord, this enrollments are for 11, class 11 itself. So it's not indicated, but it's for 11. Now, my lord, if I may bring my lord's attention to page 63 of my writ petition.
Here it was saying 25 students in class 12.
Yes.
If it is a venture higher secondary school.
Yes, ma'am.
Yours is a venture higher secondary school.
11 and 12, my lord.
Where is it 11 given? It's 12.
Yes, my lord, it's 12.
Sub rule 5 of.
Yes.
It's 12.
Yes.
But what you're showing is indicating of all 11.
No, my lord, further documents will indicate the pass percentage of my school also. So if they have been enrolled, 25 students passed also.
You see, when you're saying that you're fulfilling
Yes.
the condition 5
Yes, my lord.
of rule 3, then you must have the document to show that you have minimum 25 in class 11.
Yes, my lord.
The documents are, sorry, 12.
12.
Documents are 11. Now, suppose 1 or 2 of them have left or something has happened, we don't know.
Yes, my lord. My lord is very well. My lord, annexure 9, there has been a mismatch and there has to
Annexure?
be annexure 9, page 63.
Yes.
Now it
You
has,
followed the query of the court.
yes, yes, my lord.
Yes. 63, yes.
Because my lord, further documents will also indicate the pass percentage of class 12.
Pass percentage would be a different thing.
So my lord, if the students have enrolled in class 11, my lord,
There's no if, Mr. Singh. All right, what is this document at 63? This is issued by the additional director.
yes, my lord.
It says in this connection.
Still, it is to be started that this office has received the enrollment figure in respect of the state school in 14-16, less than 25 from the chairman Seva in the matter of provincialization of the school as per the Act 2017, which is mismatching. I therefore request you to re-verify the enrollment figures of the students of HS final year in respect of Dongobari High Secondary School under Morigaon district for the year 14, 15, 16,
Where is the
17.
report?
My lord,
Where is the report?
my lord, then they have filed their affidavit, my lord.
Yes.
For a long year, the affidavit has not been filed.
Where is that affidavit?
My lord,
Page
page,
76.
no, my lord, 107, my lord. Yes,
Page
107, annexure 1 of the affidavit.
107.
Yes, my lord. Must be running pages.
Yes.
Yes, my lord. Here it says, in inviting a reference to a subject cited above, I have the honor to inform you that the data received from your end, wide letter under reference in respect to Dongobari High Secondary School under Morigaon district is contradictory.
This is again calling for a report. Where is the report?
Next page, my lord. 108.
Hmm.
Appeared, pass, this data, my lord. 2012, 13, 14, 15, and 16 and 17, this data of the years, my lord.
No, appeared is 22 candidates.
22 candidates.
20,
Yes.
28 in 13, 14,
Yes.
21, in 2015, 25,
29.
16 again 19. And
Yes,
this
ma'am.
is in which year? Final.
Final, my lords.
Where is it mentioned?
My lord, this is for final examination appeared in past. The pass percentage.
No, but where is HS final mentioned here?
HS final examination from 2010 to 2017, my lord. In the paragraph.
Where is it mentioned?
If I may read, my lord.
Huh?
With reference to the subject cited above, I have the honor to state that the data furnished white office letter so and so dated.
All right, got it.
Yes.
All right, got it. And but as far as 2015 is concerned, is 25. Others
Yes.
is all less.
Yes,
Then
madam.
pass is all so more than 25.
More than 25, my lord.
No, only in 2015.
That is the data difference that has been mismatching, my lord, all this years. My lord.
But where is the information
My
then?
lord,
Because
my
you see, the earlier documents which you have shown
My lord.
relates to only class 11.
My lord,
What
page,
about class 12?
my lord, page 49 indicates that.
I'm sorry, I'm
That-
not being able to appreciate your contention
My lord,
because this is the
annexed-
confusion going on in the mind of this court.
I understand, my lord. My lord,
Para 40.
query is that where is that HS final year 25 student
Correct,
criteria that has been
correct.
met?
Because if you show me that, then you have a case.
Yes, my lord.
If you cannot
My
show
lord.
me, then first
Page 49, my lord, that indicates.
page 40.
49, annexure 6, my lord. This is by the Jagirod principal in charge, higher secondary school.
40.
49, annexure 6. If I may read, my lord, this page. Because
HS
next 20 pages
final.
also. Annexure 6, my lord.
Yes, please.
Enrollment of the students who appeared in HS final examination in the 3 years of 14, 15, 16 from Dongobari High Secondary School.
This is your own principal.
Yes, my lord. No, this is from Jagirod High Secondary Center in charge, my lord, where the examinations were held. So his report says, the next very page, my lord. I may read the entire annexure 6, my lord.
The numbers of such students are 6, 7, and 10 respectively in the year You read page
Yes, madam.
49, which you are first
Yes, yes, yes. madam.
showing.
With due respect,
I have the honor
to state that Jagi Road High Secondary School is a recognized center for holding the HS final examination since 14, and the students of Dongobari High Secondary School appear in HS final year examination from this center. In the years of 14, 15, and 16, some students of Dongobari High Schools were shown in the name of the center due to late admissions of their forms and documents. The number of such students are 6, 7, and 10. Now this add ups, my lord. These students have been shown under their.
This is not a document. So your whole thing is based on this document.
The
you are
records,
saying
the records,
mismatched.
my lord, where I have been maintaining 25 plus students who have passed the class 12th, and their data showed
But,
otherwise.
All these orders where they have been asked to verify and all these verifications has been done.
Yes, my lord.
And those reports are against you.
Yes, my lord. But that is a data mismatch, my lord, because the authorities have in.
But what is the stand taken by the government? Because if they are saying this is what and how the court is going to go into this disputed question of fact. Because
Lord,
according to you, it's mismatched.
The records have to be perused, my lord, in this case.
Records are available, Mr. Chutia. Records are available.
No. Actually, provincialization, we are not part of that. They are part of the government. They will file affidavit. I, on behalf of the council only, the dropout portal. Only his request to entertain his name in the dropout portal. This is minimum things. And this petition lordship kindly see page, petition page 74. He earlier approached this one. I will quote, the director has passed an order, lordship kindly see.
74.
Page 74.
Yes.
Order, seeing the peruse the order 6/9/2022 passed in duplication number so and so, by Josna Mohonto and others. As stated, the petitioner is similar Josna Mohonto are teaching and also staff of the Dongoboy Higher Secondary School under Morigao district, functioning as 11/1/1998 at the higher secondary segment in the already provincialized Dongoboy High School. The petitioner claimed that their Vensa Higher Secondary School was granted approval by the state government on 26/7/2025. Which letter he pointed out in page 41. 26/7/2025, where the government enacted new act, namely the Assam Education Provincial Service of Teachers and Reorganization of Education Institution Act 2017. The district school committee Morigao had submitted particulars of the said school along with other schools under the aforesaid act. But the Vensa school of the petitioner as well as the petitioners got dropped in the first round of provincialization exercise undertaken by the government in the education department. Being agreed, the petitioner filed this writ petition for granting the petitioner with a liberty to file it. And thereafter, next paragraph, after compliance of the Honorable High Court order dated so and so, filed by the so and so, a hearing was conducted in the office of the Chamber of Deputy Director, which was attended by the Inspector of School, MDC Morigao, the Headmaster, Dingboy High School, and petitioner, Josna Mahanto. As stated on the day of hearing, the Inspector of School, MDC Morigao, submitted enrollment status of class 12 of Dangboy Higher Secondary Schools, wherein she stated that as per letter of the Secretary, Assam Higher Secondary Education Council, Bamuni Budam, addressed to the Director of Secondary Education, Assam, the enrollment of higher secondary final year during the year 2014, 15, 16, so and so respectively. And the same letter, it was also stated that as per report of the Inspector of School, MDC Morigao, report of the principal of the Jagirwood, so and so, the enrollment shown as 27, 32, 29 respectively during 14, 2015, 2016 respectively. This one, as the enrollment report submitted earlier by the Assam Higher Secondary Education Council, the report submitted by the Inspector of School Morigao, the report submitted by the school authority was contradictory. Three organizations submitted a report, this is contradictory, as the Secretary Council was requested to clarify and resubmit an authenticated data higher order and data dated 20th November 2023. In response to the said letter, the Secretary Council submitted a report by letter dated 18/12/2023, 8/12, where it was stated that the data submitted earlier by the council letter dated 14/9/2021 is to be treated as authentic. The council also submitted enrollment data of the higher secondary final examination 2010 to 2017 in respect of the Dangoboy High School Morigao as per record of tabulation register. Now, Lordship kindly see Director of Secondary Education, as per report received from Assam Higher Secondary Education Council, Bamuni Bodam, reflect is that the total number of students appeared in the year 2020
2014 to 2021, 2015, 25, 2022 respectively, it is concluded that the higher secondary school under Morigao district does not fulfill the eligibility criteria for provincialization of service of teaching and non-teaching staff of the school under section 3.1, Roman 5 of the Assam Education Provincial Service of Non-Teaching and Teaching Education Organization Act 2017, as amended in the 2018 states. The Bhansai Education Institution has a minimum total enrollment of 25 students in class 12, 25 students in class 12, 10, 25 students in class 12. If it is Bhansai Higher Secondary School or Bhansai Junior College, 30 students in the final year of the 3-year degree course. If it is a Bhansai degree college, as on that of coming into force, has the state level school committee could not recommend the name of the petitioner, or the petitioner school could not fulfill the eligibility criteria under the Act 2017. This was the passed by the Honorable disposal by speaking order. So that's why I am serving. That's why court has directed.
Have you challenged this order?
Yes, my lord. This
You have.
petition is for.
In this
Yes,
petition.
yes.
So this order, Urdutas order, Balot, forgetting the provincialization, they only said to give permission so that they can be ballot in the portal, enter in the portal and go for provincialization. That's the state. But he jumped to the second stage.
Yes, Mr. Kaur.
My lord, say, they had a chance. In this case, there is a difference between appeared and the enrollment. The enrollment is more than 25. There are 3 reports, 2 are in our favor, and they are basing the facts or the statistics on the basis of the online report. When it was offline, then it was we fulfill all the criteria. On the basis of the appeared, you cannot say the enrollment because some students may fill up the form and they may not appear in the exam. So in this case, my lord, those records of enrollment has to be called for because that will clear the
I
issue.
think you have the records.
Otherwise,
who is going to give records?
They has not filed affidavit. But
Why have you not filed your affidavit? Anyway, you give your have the records available.
That cleans
the
issue.
Jason. Council.
Now it is designated as a Assam School Education Board. Council has filed nothing.
Assam
Assam State Education
School Board.
School Board. Assam
And
State School.
Yes.
Your Lordship. So these letters serve as my formal notice of resignation, which could be treated as the explanation towards the charge sheet following the counseling and the verbal warning of so and so, so and so. Number one, not acting, habitual leave, negligence in performing duty. This formal letter of my resignation from Liaison Numuligor Pipeline Limited, Moduban, could be treated as effective tomorrow 16 to 20. Please be assured that I have thought much about my decision and my present views with my seniors' point of view was misaligned, so I made the decision. It was purely a career-oriented work. Further, I want to express my gratitude for rewarding professional association during my employment with Duliazan Numuligor Pipeline Limited, which will be memorable for many years. Thank you. Then your Lordship will look into the next document at page 29.
Page 27, thank you for your courtesy to me. I trust that you understood this my
Yes.
final decision.
Yes.
Yes.
Then your Lordship will look at page 29, annexure 6.
Yes,
On the same day, everything happened on the same day, 15/2.
yes,
Then the company says, reference above, we would like to inform that on the basis of your resignation letter dated 15/2/2020, you are provisionally released. So we are stressing on this word provisionally released from the services of DNP Limited with effect from 16/2/2020, subject to the fulfillment of the following condition. You have to pay the 3 month salary. You have to return all the PPV and so and so. On receipt of the above, a final letter of release will be issued. This your Lordship will take note. However, you will be barred from entering the premises of DNPL's office and plant until the formalities are completed.
yes.
Now your Lordship will find.
Have you paid the 3 month salary?
That has been stated by this honorable court. In the interim.
That's 41,000 was paid.
Mr. Khanna, please take your seat.
Now your Lordship will see page 31.
Page?
Page 31. Withdrawal of
31.
the, yes, withdrawal of the resignation, madam. Annexure 7.
Yes.
I, Tapan Kumar Doctor, an old employee of DNP Limited as senior engineer mechanical, writing to apologize and to request for rejoining the job. I resigned from the job unintentionally due to some issues for which I apologize, and I'm looking to join the job. I request you to kindly consider me for the job because of my previous hard work and performance I made during my employment. I assure you that now there would be no such interception and I will perform my duties with sincerity.
When did you issue this?
On the next day,
16.
Sorry, 16/5.
16?
After 3 months.
16/5/2020.
Yes,
This is after
3 months.
3 months. And when did you file this case? After this, obviously.
Yes, sir.
And you got a stay of
This recovery.
the recovery.
Yes.
But before we go there,
Yes.
let us most likely the entire crux of the matter lies in this 15/2/2020 order, right?
Yes.
Now, here it appears that on the same day, they have provisionally accepted your request,
Yes.
correct?
Yes. ma'am.
And subject to certain conditions.
Yes.
And those condition is that you have to pay the 3 month salary
Yes.
and you have to return all the PPE, other equipments and other official belongings.
Equipments and all I have returned. The laptop and all, harness, those I have returned.
Only the salary you have.
Salary part has been stated.
And then after completion of all these formalities, the final release letter will be given. Now it appears that pending the final release letter, you have decided to change your mind.
Yes.
And you have accordingly again written a letter after 3 months saying ki, you will now, basically your request is to, you are withdrawing your earlier resignation. But where is that mentioned here? I resigned from service unintentionally due to some issues for which I apologize. I request you kindly consider me for the job because of my previous so-and-so. I made doing so-and-so and perform my so-and-so. Now they don't, now your grievance is that they have not accepted this.
Yes, they
Is
said
that your
that on the day when it was you are provisionally released, that
But
is
one thing, Mr. Poor, it appears that you have voluntarily given the letter of resignation
Yes.
in the first instance, right?
Yes.
And you have very clearly made up your mind that
Yes.
that is your final decision.
Yes.
Now, So within 3 months, instead of returning this and all, you are saying, no, you will continue,
Yes.
right? Now, they
And-
are not doing that.
Yes.
What is
And,
wrong?
and I can only draw support from one judgment of the Honorable Supreme Court, which says that anytime before acceptance of the resignation.
See, of course, I will see to that, the facts of that case, because all decision, all
Yes, yes.
laws are
Yeah.
contextual,
Yes,
right?
yes, yes.
Now, as I understand this 15-2 letter, first your letter, which you are very clearly said, this is my final decision. That word is there.
Yes.
Secondly, in their 15-2020 letter, it appears that they have simply said till the final formalities, we will keep the
Provisionally.
final release order pending.
Yes.
So it is just a matter of formalities.
Yes.
That you have to submit all this, and once you do it, they will finally release you. So they have taken a call.
Yes.
It's not that they have not taken a call, right?
Yes, absolutely.
So they have already taken a call that they're going to accept your resignation. Only formal release is
Yes.
left.
So
Now,
still the-
whether in that kind of a situation, you can again change your mind and they are now bound to accept you back. That is the
the
only
crux of the issue.
crux of the issue that has to be determined by this court.
Now your lordship will see the subsequent communications also.
Yes.
Yes. You can look also, okay? Okay. Annexure 8, your lordship will kindly look.
Yes.
Page 33.
33. Yes.
With reference to the above note, you have deliberately failed to comply with the directions indicated in this office letter referred to above to pay the 3-month last drawn salary and to deposit the PPE office equipments and other company properties in your custody as listed in the annexure attached here. Your such intentional acts of non-compliance with the said direction are contrary to the established rules, norms, and directions and are tantamount to violation of all service rules and regulation which warrant both civil and criminal proceedings against you. You are therefore requested to deposit the company properties as detailed in annexure attached herewith within 7 days from the date of receipt on your failure to comply herewith as desired, necessary instant that they ask for the equipment. Now your lordship will look into the next document at page 34.
Yes.
This is again to me.
Yes.
Reference we are to inform you as below. As requested in your resignation letter dated 15/2/2020, you were released from the company on 16/2/2020, and as such, you are no longer an employee of DNPL. However, in spite of recruited.
This was done on 10/6/20.
Yes, ma'am.
And
Subsequent.
Subsequent to that letter of yours. Where is that letter whereby you said that
As requested, the 15/2 is managed at page 26.
26.
And 16 is
That
at
is 15/2/2020.
and 16/2 is managed. From which date the petitioner, the company says that your very next day, the company says that it is effective.
Yes. This is under challenge.
Yes.
31. 34.
Mm.
Page 34 is under challenge.
Yes, yes.
Yes.
Now, what has happened actually, Malad, I can't actually during that period when I submitted my resignation letter, I was under medical treatment for some issues, but that those documents are at page 37 onwards. I have annexed as a series as annexure 10. It appears that that he was under some treatment of some mental issues. So for it refers as GAD, GAD. It's a type of disorder of the man. So that documents are there. After recovery and all, only this resignation letter was withdrawn. That's a
resignation withdrawal letter, nothing is mentioned.
Mm.
He fully understands both the letters appears to be those two letters are very clear.
yes. But only thing is that
What decision are you carrying? So
only one judgment says that of course
I think facts are these, nothing more.
nothing. Only thing is that as your lordship is saying that we can't pick up a particular line from a judgment and say that it has to be ultimately it has to be read in the context of the facts of
The fact that your first letter is very
Yes.
clear.
Yes.
It had no scope of And it is not your case that you have been coerced, because sometimes what happens, you
I
are
appreciate
forced. Lot of times we see these going on in these disciplinary
Yes.
matters, labor court matters. That is not your plea, right?
But
It
I-
appears, only thing now you have brought out a new plea in your, after filing this petition, that some mental issues were there.
Yes.
But that also doesn't appear from reading of those two letters, because those two letters appears to be.
No, well, what is
Yeah,
not
whatever
there,
is there.
I cannot ask.
Correct, correct.
Great record.
Correct, because those two letters otherwise doesn't doubt the.
Your Lordship will kindly look only one paragraph at paragraph number 22.
Yes.
It is now settled, paragraph 21, my lord. The paragraph 21, then this parenthesis G. It is now settled legal position that unless the employee is relieved of the duty after acceptance of the offer of voluntary retirement or rejection, dual relationship of the employee and the employee does not come to end. Since the order accepting the voluntary retirement was a conditional one, the condition ought to have been complied with. Before the condition could be complied with, the appellant withdrew the scheme. Consequently, the order accepting voluntary retirement did not become effective. Thereby, no vested right has been created in favor of the respondent. Therefore, the High Court was not right in holding that the respondent has acquired a vested right, and therefore the appellant has no right to withdraw the scheme subsequently. In J. N. Srivastava versus Union of India, a notice of voluntary retirement was given to an employee on 3/10/1989, which was to come into effect from 31/1 of 1990. The notice was accepted by the government on 2/11/1989, but the employee withdrew the notice by this letter dated 11/12/1989. It was held that withdrawal was permissible, though it was accepted by the government, since it was to be made effective from 31/1/1990, and therefore that date it was withdrawn. So, your Lordship will now go, all the judgments have discussed, paragraph number 26.
Yes.
On the basis of the above decision, in our opinion, the learned counsel for the appellant is right in contending that though the respondent company had accepted the resignation of the appellant on 4/1/1993 and was ordered to be relieved on that day, by a subsequent letter he was granted casual leave from 5/1/1993 to 31/9/1993. Moreover, he was informed that he would be relieved after office hours on 15/1/1993. The vinculum juris, therefore, in our considered opinion, continued, and the relationship of employer and employer did not come to an end on 4/1/1993. The relieving order and payment of all salary also makes it abundantly clear that he was continuing in service of the company up to 15/1/1993. So since here that other
Yes.
Then the next page, your Lordship will look the parenthesis B also. It says that here also the conditional acceptance of the
taken note of
not note of,
Have
because
taken
the
note of.
other conditions are not there. So
Anything more?
So my humble submission is only to that effect, and this recovery part has already been stated by the
All right. Yes, Mr. Khanna.
My lords, this case law which has been referred to, it does not apply to this.
We'll come to the case law later. First,
My lords.
what have you done to the letter that was given subsequently?
My lords.
Why,
My lords,
I don't find any reference about that letter in your subsequent action whereby you said he's released.
My lords,
If this court looks into both the letters, it appears they're two contradictory. Because first you say that provisionally released subject to fulfillment of conditions A, B, C, right?
Yes, my lords.
Now that is your stand. Subsequently, in between, before you finally release him, he says he apologized and he wishes to continue. Thereafter, you simply release him.
Yes.
But I don't find any reference to his.
My lords, I'll point you to the
Yes.
government.
Let us have a look at those orders first, and then we may
Yes.
proceed. Page 26. First one is?
Annexure number, it's annexure number 6, page 26.
Yes, let's come to page 26. 26 is his letter.
29, my lords, is the typed copy of annexure 6.
Yes.
My lords, it says the reference says your resignation letter dated 15/2/2020.
28, right?
28 and 29, my lords.
Yes. Yes. Type copy.
Reference above, we would like to inform you that on the basis of your resignation.
Yes, there is no doubt about that.
My lords, I'm on the jurisprudence.
See, we'll come to jurisprudence later. First of all, the facts.
My lord.
Let us be clear with the facts.
My lord.
The issue that you have to show is that whether he continues in service or he is not. That is the issue, because the jural relationship will come, right?
Yes.
Now, with this letter of 15 to 2020, can it be said that the jural relationship has come to an end or not?
Yes, my lords.
So you show
Yes,
that.
yes.
Read.
Reference above, we would like to inform you that on the basis of your resignation letter dated 15/2/2020, you are hereby provisionally released from the services of DNPL Limited with effect 16/2/2020. Subject to the fulfillment of the following condition. You have to pay 3 months salary, PB, GP, and DA. You have to return all PPE, office equipments, and other official belongings issued in your name, if any. On the receipt of above, a final release letter will be issued. However, you will be barred from entering the premises of DNPL office and plant until all formalities are completed.
Yes.
My lords, I have released him with finality. The only thing this letter gives rise to is recovery proceedings, should he choose not to return my equipment, or for that matter, the dues which are basically pending to my credit, my lords, from the employer.
How do you interpret the word provisional?
Yes, my lords. Now,
What according to you the word
My lords,
provisional means? What according to you the word final release letter would mean?
my lords,
How do you?
my lords, may have this issue has been discussed in very case laws, my lords. There is a convenience set before your lordship, which I have compiled, my lords. There's a convenience set before your lordships. I've already filed it, my lords. I'll show this issue
Where?
via case laws, lords.
Yes. Where is the
It's part of my written submissions.
Where is the written submission?
It's in the file, but I made sure of it this morning. You have not given us a picture.
You have not submitted to the other side, Mr. Khanna. You have submitted documents
There
before
was
the
a
court.
copy supplied earlier also, my lords.
Huh?
There were several adjournments. I think there was a confusion.
No, adjournment is a different matter, but if you submit anything to the court, the basic courtesy is to give it to the other side.
My senior was not present at that point, my lords. I supplied a copy to his associates, my lords. I did.
Written submissions on behalf of R2. Yes, what do you want to show from here?
My lords, this is a Supreme Court judgment. This is Santosh Hegde. So I'm sorry, Dot Zone Cultural Center versus Vedpati.
Which one? Serial number, which one? North Zone. Yes.
Number 5, my lord.
All right.
North Zone.
All right. Yes, what do you want to rely
My lords, may have para number 22.
All right, we'll come back at 2.
Yes. By way of context, my lords, your lordship's query was how have I dealt with the letter which was issued to me on 15/2? Before I get into the case laws quoted by me, my lords, I'll draw your lordship's attentions to my affidavit in opposition, para number 6.
You are for the?
For respondent number 2, my lords.
Who is R2?
DNPL limit, DNP limit. The employer.
State of Assam is also a party.
State of Assam is also.
DNP Limited. It's a government of Assam undertaking. Yes, affidavit filed by you.
Yes, my lords, running page number 51.
Yes.
Para number 6.
Yes.
That with regard to the statements made in para number 7 of the writ petition under reply, your deponent states that on receipt of the charge sheet, the petitioner unilaterally and without any condition on 15/2/2020 submitted his resignation letter, which is annexed at annexure 5 to the writ petition, and stated therein that his resignation be treated to be effective from 16/2/2020. His resignation letter dated 15/2/2020 in his, sorry, my apologies, my lords. In his resignation letter dated 15/2/2020, the petitioner emphasized that his decision to resign was a much thought out one, and the same was purely a career oriented. Para number 7, my lords, that with regard to the statements made in para number 8, your deponent states that on receipt of the resignation letter, the same was processed, and the same on being accepted, the petitioner was provisionally released. And my lordship's query is on this phrase, my lords, provisionally released. And my lords, may now come to para number 8, my lords. The provisional release of the petitioner was necessitated in as much as the petitioner had not refunded the amount due from him, and also the equipments and the files of the organization lying with him. It is further stated that the resignation as submitted by the petitioner, being an unconditional one, had come into effect with effect from 16/2/2020. The resignation in the organization is of
unconditional.
My lords. Now I'm
You
coming.
can't be blowing hot and cold.
My lords. Now the
plain perusal of the letter
my lords.
indicates it's a conditional one.
My lords.
You are right that it is, you have taken a call, but you said subject to the following conditions.
Yes.
That means it is a conditional. It cannot be said that it is an unconditional one.
I appreciate.
And why I am saying so, because this is a case where he himself has said, I want to resign.
Yes.
Therefore, there is a right given to him that before that final decision is taken, before he's finally out, he may still
my lords, I'll
change his
distinguish.
mind.
I'll distinguish that,
Correct.
my lords.
Now, one thing which cannot be disputed is that it has not come into force, because you yourself have said that it is subject to the following conditions.
My lords.
Yes, in principle, you have accepted it.
My lords.
There's no doubt about it. That in
However,
principle, you have accepted. But you have still not given the final release order.
my lords.
You said subject to the fulfillment of condition 1, 2, 3.
My lords.
Right?
My lords.
The final release order is not out.
I'll distinguish that, my lords. In such cases, my lords, and the courts have now this point in contention has been well settled. My lords. There's a series of judgments which starts from 1963, my lords, all the way to 2025. The position is this, that it is on there is a prerequisition which can only get activated if at all there is a specific rule in the management HR rules, which the petitioner had to establish, my lords, that upon, my lords, I'll rephrase. The only way when there's a voluntary resignation by an employee, which can be extended if it has not been accepted already by the organization, and if there is a wordplay of provisional and so on and so forth, my lords, can only be looked into if there is a specific rule in the HR rules or the management rules, my lords. And this position is coming from the case laws, my lords. I mean,
That is different. That is also
Right.
contextual, right?
So,
But here, one need not go that far.
my lords.
The letter,
Yes,
of your first letter itself is clear.
my
A
lords.
provisional,
In fact,
subject to fulfillment of so-and-so
My lords,
condition, final release.
the
Now, before that final release, you have issued the order.
My lords, in fact, and this is now a position of law, my lords, there was absolutely no need for me to even issue this letter. This letter has been issued. I'm not contesting that. However, the law states that once a employee voluntarily, without any scheme, my lords, there is no scheme which comes to his benefit. There are certain, voluntary resignation schemes and retirement schemes and so on and so forth. So this is not the case today before your lordships. The situation is very simple, my lords. This resignation was in response to a show cause notice which I
Are
had
you
issued.
trying to say that he is stopped to resign?
Yes, my lord.
Is that what you're trying to say?
No, my lord. No, not a stop to resign. My lords.
Resign.
Sorry.
A stop to go back.
Yes, my lords. There is an estoppel. And the estoppel is not only in fact, my lords, there is an estoppel in law as well. They had to show to this honorable court, my lords, that there was a specific rule within the HR rules or the management rules which comes to his aid, my lords, and I will show this particular point from the case law.
No, let us see what case law
Yes,
you
my
have,
lords.
because as of now, I'm
my
convinced
lords,
with
just bear
the
with me.
argument of the senior counsel that until and unless the employment comes to an end by issuance of the final order,
I will show to your lord.
employee can
Yes, very well.
resile from the resignation
Very well,
which
my
he
lord.
has submitted.
Yes, my lord. Very
That,
well. I will-
that is very clear with the judgments of the apex court
My
that
lord,
has been
I'll-
placed before this
I'll
court.
show-
Now you want to show something else, show.
Yes, my lord. I'll show to your lordships the entire jurisprudence which has been well settled on this very point, my lords. Now, this is, my lords, it starts, the jurisprudence starts with this case called Rajkumar versus Union of India, my lords. This is still good law.
Yes, let us see what is this jurisprudence that you want to show.
Yes, ma'am. That's it. I have. That it's the very first judgment annexed with
Yes,
written
yes,
submissions, my lords.
yes.
This is para number 6 of the judgment.
Yes.
Our attention was invited to a judgment of this court in state of. Malab,
Yes, yes.
Our attention was invited to a judgment of this court in state of Punjab versus Amar Singh Harika, in which it was held that an order of dismissal passed by an authority and kept on its file without communicating it to the officer concerned or otherwise publishing it did not take effect from as the date on which the order was actually written out by the said authority. Such an order could only be effective after it was communicated to the officer concerned or was otherwise the employment by order passed by the government does not become effective until the order is intimated. But, my lords, and this is where I'm trying to distinguish. But when a public servant has invited by his letter of resignation, determination of his employment, his services normally stand terminated from the date on which the letter of resignation is accepted by the
In this
appropriate-
case, it is not a
My lords,
conditional.
I'm reading, my lords. It will not be open to the public servant to withdraw his resignation after it has been accepted by the appropriate authority. Till the resignation is accepted by the appropriate authority in consonance with the rules governing the
That is all right.
acceptance. My lords, I'll read further. The public servant concerned has a local potential, but not thereafter. My lords may then see the paragraph straight under that very
This
paragraph.
is not of relevance. Next case.
My lords.
Next case.
My lords may then have North Zone Cultural, my lords, that's the judgment number 5.
You're not relying on Chanmal Chayal?
Not Chanman Chalan.
You're not relying?
I don't have that judgment.
No, you have given it in your compilation. That is serial number
I
2.
apologize.
Are you relying or you're not relying?
Yes, that's judgment number 2, my apologies.
Yes. Are you
I
relying?
have, my lords, the operating paragraphs are 3 and 8.
Yes, let's see if this has some relevance.
By now, it is well set, my lords.
Yes, please.
By now, it is well settled principle of law that an incumbent is entitled to withdraw his resignation before the acceptance. Once his resignation is accepted, there is no dual relationship between the employee and the employer. And the employee cannot claim for withdrawal of the resignation or reinstatement in the post. In the present case, it is not very clear in the application submitted
This
by.
again is of no, in fact, in fact, it
There-
helps the other side.
Yes, but
You
I
see,
was-
in the facts of this case, in paragraph 3, it is indicated.
My-
In that case, it was not clear from various correspondence between the High Court and the
Therefore-
government that he seeks for re-employment.
Therefore, I was on North Face, my lords. North Face is much more clear. It's a much more recent judgment also, my lords.
Huh?
North Face judgment, my lords.
Mr. Khanna,
Yes, ma'am.
you have submitted this compilation with all
My
these
lords,
case laws.
the-
So if you don't want to press, you may say so. Otherwise, this court will have to deal with it because you have
lords,
submitted a written argument.
What I'm trying to show your lordships by way of this judgment is that the exception, the resignation was accepted on the very day that it was given to me. by
No,
us.
no. That doesn't say in this.
No, my lord. I'm trying to show this, my lords.
How can you read something which is not there? Paragraph 3 is very important. Paragraph 3, Mr. Khanna.
My lords, I'm not on that judgment. What I was submitting was.
But paragraph 3 of this judgment.
My lords.
Let's read it together. By now, it is well settled principle of law that an incumbent is entitled to withdraw his resignation before the acceptance.
Before the acceptance.
Correct. Before the acceptance. Now you see, you are trying to interpret that first letter as your acceptance.
Yes.
Now, therefore, you see, you've been referring to the settled jurisprudence. As regards this position of law, there is no quarrel. But you have to show from the facts of your case that the first letter itself is accepted.
My lord.
If you succeed in that, then you have a case. Have
my-
you followed?
Yes, absolutely. my
Because
lord.
the law is settled.
Yes,
Till you accept it, they may withdraw.
My lord,
There's no doubt about
my
it.
position is this, that they was.
All right, let's go to that not.
Yes, my lord.
Which is that not?
North Zone Cultural Center, my lord, that's on, in the convenience set is number 5 judgment.
But you have not paginated.
Yes.
So it's difficult to go. I don't know which one is this. Serial number 5.
It's a Manupatra judgment. Manupatra judgment. Reported in Manupatra, my friend, and then it's the Manupatra judgment.
I don't know. I don't know about you, Mr. Kumar, but I'm more comfortable with the SSC printouts.
Yes, yes. No, nowadays, see, my lord, why I think, my lord, the younger councils are preferring the Manupatra, because this time the SSC online version has come to the 38,000 is the basic one, and the premium one is 60,000. So I have advised many of the junior council that they can share the subscription between 4, 5, and because nobody logs it at the same time.
True.
That way, that's why.
Yes, this is in the same compilation.
The same
no?
compilation.
1 second. Let me spot it from here then. Oh, I got it.
Because nowadays, if you have the Manupatra citation, you can
have
write
all the
that.
high courts.
You can,
I've opened it.
and you
No,
can.
I got
And you can write the cross citation of the equivalent citation
Yes.
of the SCC also.
Yes,
But
Mr.
I am comfortable with SCC. Even if I find it in Manupatra.
No, I generally go back and I get the SSC print.
But nowadays I have stopped printing. I rely more on the online version.
True. Yes, paragraph.
Paragraph number 12, my lord. 11, my lord. It starts with 11.
All right. Let's see. Yes, whether accepted or not accepted. Read.
The question therefore for our consideration is whether the resignation of the respondent was accepted by the appellant on 18/11/1988 or not. This is the
Yes,
point
read.
The respondent has denied this factum of acceptance of resignation on 18/11/1988. In the writ petition filed by the respondent, he has stated that the resignation was accepted only on such and such day. My lords, my position is that it was accepted on the same day.
We will come to your
Yes,
position later. Read.
My lords may then come to paragraph number 16.
Let's read. Let's understand the facts of this case.
My lords, but the appellant in the reply to the said allegation of the respondent in the writ petition filed a counter affidavit specifically denying the allegation of the writ petitioner, respondent herein, and had contended that the resignation was accepted on such and such date itself, giving certain particulars of the said fact. The appellant herein is in the said writ petition also filed 2 affidavits of the officials of the organization in support of its stand that the resignation in question was actually accepted on such and such date itself. No rejoinder, paragraph number 14, madam.
Yes.
No rejoinder was filed as against the said reply, nor the contents of the affidavits denied. Further, from a perusal of the judgment of the learned single judge, it is seen that he also accepted the statement in the affidavit of the director of the appellant organization that the resignation was accepted on such and such date, but he held that because the said acceptance only was communicated on a later date, that is 1/12/1988, and in the meanwhile, the respondent has withdrawn the resignation, the subsequent communication of acceptance had become redundant. He further held that permitting the respondent to attend duty till such and such date also showed that the resignation has not.
You can't derive benefit only because of this part. But you see, this is not a conditional. Mr. Khanna, if you show me this was a conditional one, then it is a different matter. It appears that the acceptance was taken but communicated at a later date. And the case of the petitioner in that case was that because it was communicated to him on such and such date, therefore the acceptance would mean from the date of communication. Correct? This is how the facts are. Now let us see what the apex court have said. This is the facts.
But there is one more fact your lords may note, my lords, in this particular case, wherein in this particular case, my lords, the employer also insisted that I have attended the or marked my attendance in the organization. Here, I have debarred him from the very first day.
All right.
So therefore, now, my lords may take paragraph number 16 of the same judgment.
Yes.
Therefore, it is clear that non-communication of the acceptance does not make resignation inoperative, provided there is in fact an acceptance before the withdrawal. Manos, I'm accepting the situation. What my position is that the provisional acceptance was only, and comes from my
Sorry,
working
Mr.
background,
Khanna.
Manos.
Sorry.
Manos.
I would have been with you, but the decision that has been placed from the other side is very clear.
But Malos, that is not, that speaks of a different scenario altogether, Malos.
The decision
That case, Malos, there was a scheme.
1997 or decision. Palaniki.
That was a case where there was a scheme of retirement and resignation, Malos.
Your lordship is referring.
That does not apply.
Judgment, your lordship is.
That Power Finance Corporation, which is referred in the judgment that you had given.
Yes,
that Pramod Kumar Bhatia.
The facts are different. The jurisprudence is different, Malos. There's a scheme
Mr.
under which-
Khanna,
Yes.
you are an officer of the court.
Malos.
You must know
I apologize.
what jurisprudence is different. Facts could be different. Jurisprudence, what is the settled? First, you tell me what is the settled principle of law.
There are
The settled principle of law is that unless and until it is accepted, they have a right to withdraw. Correct?
Yes, Malos.
It is correct. Now, the issue that is fall for determination in this case is whether you have accepted it or not. To appreciate that part of the issue, one has to look into both the letters.
Yes, Malos.
Now, the first letter is very clear: conditional,
Yes,
provisional,
yes.
final release. The decisions that have been also given by the other side are of the same, almost of the similar facts. Now, how do you distinguish that?
Yes, that is what I was on.
Yes.
Malos. The case laws, the case law, which has been relied upon on the by the petitioner, my lords, if my lords may see, it talks about a certain situation which the resignation or the retirement as such was secured under a scheme, my lords. There was
That cannot. That doesn't alter anything. In fact, that decision which you rely also, which is that second decision which you had relied,
my lords pointed me towards Chanmal Chayal.
which I said was in, yes.
Well, no, there was a different context to that.
No, but that in that decision also, it has been clearly said, once his resignation is accepted, there is no jural relationship between the employee and the employer, and the employee cannot claim for withdrawal of the resignation nor reinstatement in the. That is the settled principle of. Irrespective of any scheme, rules being there or not. That is the settled principle.
My lords. But here,
Now, anything more?
I'll just leave your lordships with just my
Yes.
concluding
Yes.
line, my lords. My lords may have paragraph number 10, it's page number 9 of my written submission.
Yes, please read.
That the Honorable Supreme Court in such case that has held that it is a settled legal position that the jural relationship of the employee and employer comes to an end. Now, I was on the same point as your lordship. When the employee is relieved of the duty, my lords, and this is what I'm stressing on.
Sorry, you are reading that. That could be in added circumstances, but just because you are released or not released doesn't make any difference. All right, point noted, rejected. Sorry. Yes, Mr. Kumar, anything you want to add?
Well, facts are clear. Well, when facts are clear, it will come to the case law. First is that I submitted my intention to resign from it. They said that final orders will follow later. When I withdraw my resignation, then the final orders come that it is effective from that. Prior to that, there is no acceptance of my resignation. I have placed only one judgment. I can burden my lords with another 2-3 judgments. But the law is saying
that you have
that
given,
any point of
it cites a
power corporation is there.
correct, a lot of there, but
I can give that power corporation also.
I have already got it.
Yes.
Which is the paragraph? Can you point out? It is
Yes.
7.
Just
Six,
paragraph 7.
Yes, can you read it?
It is now settled legal position that unless the employee is relieved of the duty after acceptance of the offer of voluntary retirement or resignation.
After acceptance.
Yes. Jural relationship of the
See,
employee.
Mr. Khanna, mere relieving will not do. That is not sufficient. After acceptance, both has to be there. In your case, yes, you have relieved him from the duty. That letter says, right? But you have not accepted because final release order is not come. Yes, you are right. It's a mere formality. But-
add one more thing.
But you see, unless and until you complete that formality, you cannot say that the rural relationship
My
has
lords,
come.
then consider this point, my lords. For then, my lords, the scenario will be this, that I provisionally accept, and then he can now hold me to ransom. He will not, nobody will come back with my laptops. Nobody will come back with my dues. Nobody will come back with my dear allowance.
In that
My lords, this is a
situation,
dangerous situation that will
in that situation, you are not going to release him. You have not accepted.
My lords, I will
You
initiate
can
a
start a
recovery
discipline. No, you can start a disciplinary proceeding against him if you wish to.
And if I don't return, he can
Yes.
also file a FIR
Yes.
against me, complaint against
But
me.
what?
All right, Mr. Khanna. Yes, Mr. Kaur, paragraph 7.
Yes, madam. It is now settled legal position that unless the employee is relieved of the duty after acceptance of the offer of voluntary retirement or resignation, dual relationship of the employee and the employer does not come to an end. Since the order accepting the voluntary retirement was a conditional one.
Correct.
The word conditional, the conditions ought to have been complied with. Before the conditions could be complied with, the appellant withdraw the scheme. Consequently, the order accepting voluntary retirement did not become effective. Therefore, no vested right has been created in favor. Well, there's series of judgment. Basically, at the end,
What is the scheme they're mentioning? In this case, in the facts of this case, there was some scheme, under which one was,
Yes.
one could,
as the voluntary retirement scheme is there in different departments. At the end of the day, my lord, if the
see, the
ratio that
basic ratio
emerges-
is that until unless the dual relationship comes to an end,
Yes, you have to accept my resignation. That's the end story, my lord. We are blessed.
take down. Heard Mr. B.D. Kaur, Learned Senior Counsel, assisted by Mr. H. Agarwal, Learned Counsel for the petitioner. Also heard Mr. K. Khanna, Learned Counsel for respondent number.
Respondent number 2, madam.
Respondent number 2. None appears for the state respondent on call. Yes, counsel, take your seat. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking inter alia the impugned provisional release letter number 50, letter dated 15/2/2020 and which is the final letter whereby you said you have accepted, that is dated 21/5.
Just a minute.
Annexure? And the impugned letter dated 10/6/2020, whereby the petitioner was finally released from service. The brief facts of the case is that the petitioner was serving under the respondent number 2, which is an undertaking of the government of Assam. Initially as engineer within bracket mechanical, and later on in the higher grade of senior engineer within bracket mechanical, with effect from 16/4/2019. It appears that, no, not it appears, that since December 2019, since December 2019, the petitioner was occasionally absent from duty in view of the fact that he was suffering from generalized anxiety disorder, for which he was served with a charge sheet dated 15/2/2020. Alleging on the allegation that he is habitually late and irregular attendance. Stop. Enter it here. It appears that thereafter on 15/2/2020, the petitioner submitted a resignation letter, and on the same date, the respondent number 2 issued a provisional release letter. However, later on, the petitioner on 16/5/2020 submitted a letter to the respondent number 2, intimating that requesting him to rejoin his service with apologies for his actions. Stop. Thereafter, the respondent number 2, by letters dated 21/5/2020 and 10/6/2020, directed the petitioner to refund 3 months' salary and to deposit the company's equipments, as he was no longer in the company's service since 16/2/2020. Situated thus, the present writ petition has been filed. Mr. K. Khanna, learned counsel for the petitioner, submits that, Mr. B. D. Kaur, learned senior counsel for the petitioner, submits that the respondent number 2 has provisionally accepted the resignation request of the petitioner, subject to conditions and since the petitioner, before the issuance of the final release order, has withdrawn from the request made earlier, the respondent authorities ought to have accepted and ought to have allowed the petitioner to rejoin the services, and therefore the impugned final release order is bad in law. In support of the aforesaid submissions, he relies upon the following decision of the Apex Court. Number 1, Power Finance Corporation Limited versus Pramod Kumar Bhatia, reported in 1997 for SSC at page 280. Number 2, Srikanta SN versus Bharat Earth Movers Limited, reported in 2005, volume 8, SSC 314. Per contra, Mr. K. Khanna, learned counsel for the respondent number 2, submits that Once the letter of resignation of an employee has been accepted by the employer, it will not be open to the employee to withdraw his resignation. In support of the aforesaid submission, he relies upon the following decisions of the Apex Court. Number 1, Rajkumar versus Union of India, reported in 1968, 3 SCR 857. North Zone Cultural Center versus Vedpathi Dinesh Kumar, AI reported in AI 2003, Supreme Court 2719. Chanmal.
Follows not present.
He further submits that the letter of resignation dated 15/2/2020 was admittedly voluntarily tendered by the petitioner himself, and immediately upon receipt of immediately upon receipt of notice of the charge sheet dated 15/2/2020, he further submits that the petitioner, instead of replying to the charge sheet, tendered his unilateral and voluntary resignation. He further submits that the petitioner has not cited and or invoked any rule and or provision whatsoever governing the conditions of service and employment as made applicable to the respondent number 2, which confers upon the petitioner a right to be reinstated in service or employment after the resignation of the employee has been accepted by the employer and or has taken effect. He further submits that the letter of resignation dated 15/2/2020 was processed and accepted by the respondent number 2 on the same date by issuing the provisional release letter, and therefore the petitioner was released from service with effect from 16/2/2020 and hence the subsequent letter of the petitioner withdrawing the earlier request for resignation is of no consequence. He further submits that it is abundantly clear that the resignation of the petitioner was unequivocally accepted by the respondent number 2, since the petitioner was expressly barred from entering the premises of the office and plant of the respondent number 2 until all formalities are completed, and only the issue of the final release letter by the respondent number 2 to the petitioner was made subject to the conditions, subject to further conditions. As such, he submits that the petitioner was wholly and absolutely relieved of his duties with effect from 16/2/2020. That's all? I have heard and I have given my prudent consideration to the arguments advanced by the learned counsels appearing for the contending parties and have perused the materials available on record. I have also considered the case law cited at the bar. It appears that after the petitioner was issued a charge sheet on 15/2/2020, alleging that the petitioner is habitually late and irregular in attending his duties, amongst others, which constitutes misconduct, comma, the petitioner on the same day itself submitted a resignation letter to the respondent number 2, apt to refer to the said letter dated 15/2/2020, which is reproduced hereunder for ready reference. Quote unquote, page 26, A to A. Reading of the aforesaid letter, comma, it appears that the petitioner has tendered his request for resignation from the service, from the subject post. So, thereafter, on the same date itself, i.e. 15/2/2020, the respondent authorities has issued the provisional release letter, which is also reproduced hereunder for ready reference. Quote unquote, page 7. A perusal of the aforesaid letter indicates that the respondent authorities has provisionally released the petitioner from service with effect from 16/2/2020, subject to fulfillment of the following conditions. 1, 2. And upon fulfillment of the aforesaid 2 conditions, final release letter shall be issued. While the matter rested there, it appears that on 16/5/2020, i.e. after 3 months from the date of the provisional release letter, release order, comma, the petitioner requested for rejoining the subject post by stop, which is stop no comma, which is also reproduced hereunder for any reference. Page 31, A to K. A reading of the aforesaid letter indicates that the petitioner, having realized that he has unintentionally, that he resigned from the job unintentionally due to some issues for which he sought apology and requested the respondent authorities to consider him back in his job. It appears that after receipt of the aforesaid letter, immediately the respondent number 2 by letter dated 21/5/2020 directed the petitioner to deposit the company's properties within 7 days from date of receipt of within 7 days failing which necessary action shall be initiated. It further appears that thereafter the respondent authorities by letter dated 10/6/2020 informed the petitioner that he was released from the company's service on 16/2/2020, and as such he is no longer an employee of the under the respondent authorities. And further directed him to deposit the salary in lieu of short notice and advance taken from the company and deposit other items issued to him during his service in the company. Now, apt to reproduce the aforesaid letter dated 21/5/2020 for ready reference, quote unquote, page 33.
Page 34.
34, sorry. Yes, 34. Perusal of the aforesaid communications it appears that the petitioner has what transpires from the above is that the issue that falls for determination is whether the respondent authorities has accepted the resignation of the petitioner prior to the petitioner's request for remaining in the job in question. It is well settled law that until and unless the resignation, the voluntary resignation request is accepted by the respondent authorities, comma, the petitioner is entitled, not the petitioner, the employee is entitled to withdraw from the said request. Reference is made to the decision of the apex court in the case of Power Finance Corporation Limited Supra. Paragraph 7 of the aforesaid judgment is quoted hereunder for any reference, quote unquote, para 7. Reference is also made to the decision of the apex court in Shrikanta SM versus Bharat Earth, Shrikant SM Supra, paragraph 21 to 26 of the aforesaid judgment is reproduced hereunder for ready reference. In the present case, it is apparent that the provisional release letter issued by the respondent authorities is subject to fulfillment of conditions stipulated therein. It is further apparent that until and unless the aforesaid conditions are fulfilled, the final release letter shall not be issued. That being so, until and unless the final release letter is issued, it cannot be said that the jural relationship between the petitioner and the respondent number 2 has come to an end. That being so, until and unless the final release order is issued, the petitioner is entitled to withdraw the resignation request. Stop. Since, stop. It is admitted position that the final release letter, and it is admitted position that no final release letter in the instant case has been filed till date, has been issued till date. Correct? Because that letter is not final.
I can see.
Yes. In stop. The argument of Mr. K. Khanna, learned counsel appearing for the respondent number 2, to the effect that the provisional release letter itself is final release of the petitioner, is totally fallacious and cannot be accepted. The decisions relied by Mr. Khanna comma, it is apparent that the settled principle of law that emerges out of the aforesaid decisions is that until and unless the resignation request is accepted, the petitioner, that the employee is entitled to withdraw from such request. In view of the aforegoing, I am of the considered view that this writ petition succeeds Accordingly, the provisional release letter dated 15/2/2020 and comma, the letter dated 21/5/2020 and the letter dated 10/6/2020 are hereby set aside and quashed. Repetition stands allowed. Sorry. Yes.
Obliged.
I'm going to edit a little bit, so you may not get it today. May take 1 or 2 days.
My lord, by way of last, as far as the number of prayers, my lords, in the
I have seen, I have not given them the first prayer. I have not said anything, but I have indicated what I have said aside. Charge sheet I have not touched. And they have not even argued. So you see, they may take a lot of point and they may make a lot of prayer. They are entitled to make as many prayer under the sky. But ultimately, it matters what they're going to press before this court. This court is only going to look into that.
I have not challenged it also. And breaking period, my lord, that consideration there. Breaking period because of this, your lordship may consider. Because that's a consequential relief. This gap period.
That I'm setting it aside and you want that line be added as and all the consequential relief be granted to that effect.
In the judgment only, your lordship will look at para 29.
Para 29.
Yeah.
Para 29.
For your lords, for your lordship's consideration, my lords, if there is no interference on the show cause notice which has been issued, my lords may say that the
Mr. Khanna,
my
you
lord,
are
my
all
lord,
you are at liberty to go ahead with that charge sheet in accordance with law.
my lord.
You want me to clarify that?
No, my lords, it was because there's a suggestion which came from the opposite side, so that